Yes, good morning. Welcome back. So we are going to go into the next session that is going to be chaired by Honorable Chief Justice Dr. Mumba Malila from Zambia. In fact, before I ask you to invite your panelists, it looks like both are going to be online, and I hope that they're now. But anyway, Dr. Mumba Malila, as the Chief Justice of Zambia, has really given support to the Africa Electoral Justice Network, as well as to the judiciary of Zimbabwe, by bringing a large delegation of Zambian judges to this symposium. So we thank you very much for that, because it really shows a different type of approach to holding events by African jurists, in that whilst the network as an entity that is still at its infancy and did not have enough resources, we've been able to leverage on the contribution of individual judges as well as judiciaries to actually self-finance their own presence here. And so it's something that is very unusual, because of the fact that many of us rely on donors and on development partners to finance our own initiatives. So here, I think this unique model where there is a contribution from judiciaries themselves, which I would really call broadly African philanthropy to deal with our own problems, I really appreciate it. And so, Chief Justice Mumba Malila, I thank you a lot on that. May I hand this session over to you to get us off for the session.
Thank you very much, moderator, for the introduction. I will ride on the protocol as already laid out, but I need, first of all, of course, to acknowledge and thank our host, Chief Justice, Justice Malava, and the Judicial Service Commission of Zimbabwe for the warm welcome and hospitality that has been accorded to all of us since our arrival for this very important meeting. This session is devoted to discussing the concepts of constitutionalism, good governance, and electoral justice. And in fact, the session is intended to lay the foundation for all the other discussions that we are going to have during this the next 2 days or so. The keynote presentation, well, let me just say that the session will be divided in three parts. First of all, there will be a keynote presentation by Chief Justice Malaba, and then there will be a panel discussion by two persons, yeah. And thereafter, we shall have the plenary. And you will be free to then make your contributions and ask your questions during the plenary. So the keynote presentation that we're going to start with is fittingly being delivered by Chief Justice Malaba of Zimbabwe. His biography appears in the brochure that has been distributed, so I don't need to go through it. Safe to say that he is, of course, he's got a very rich bio, and he's been both Deputy Chief Justice and Chief Justice, and has been a judicial officer in all for about 39 years. So Justice Malaba will have 30 minutes to make his presentation, but he has assured me that 30 minutes is probably too much for him. He knows how to abridge his presentation, which he has promised to make available to the participants at a later stage. So let me invite Chief Justice Malaba to the podium now.
Thank you very much, Chief Justice Malila. Once again, I welcome all of you to this meeting. I'm wearing a different hat now. My topic is really meant to bring into focus the fundamental principles that govern what we are here about. The fundamental principles that govern the matters that have brought us here. Constitutionalism. We are all here because of this principle. It's a foundational principle. It's a principle that embodies culture, societal culture, the way people accept how their legal relationships must be governed. It also involves accepting the higher principle that it is proper to act in terms of the law. That's very critical. So it is both a principle of action in terms of correct action, in terms of prescribed action, not in terms of arbitrariness. But at the same time, once it is that, it also involves self-redefinition. It involves self-redefinition, a conscious, deliberate acceptance of submission to standards. Because if we don't do the two, if we can't accept holding others to higher standards, whilst at the same time accepting that we submit ourselves to a higher standard by which to measure others, then we will have failed. And we can only do that in objective terms by reference to fundamental values. By reference to fundamental values and the principles of action. In other words, there are fundamental principles which demand particular, specific conduct. That is what we are here about. That is constitutionalism. But what is constitutionalism without a constitution? So the constitutionalism as a fundamental principle I have defined, both psychologically, practically, demands that they be a standard of supremacy. They be a standard of supremacy. All of us here come from countries that have constitutions, hopefully. All of us in Africa have chosen, deliberately chosen for ourselves, I said it earlier on, the route of compliance with those principles that we as a people of Africa have decided to submit to voluntarily. Whether it be through the AU, it's a mechanism, it's a medium. The AU is a medium of setting up these standards. But we incorporate all these standards that we're talking about. The charter, the principles, the values which are in the charter on democracy, elections, and governance. Those principles are brought down and incorporated in our constitutions. Once they are incorporated, they begin to be part and parcel of the prescription of obligation. They become part and parcel of the principle and the prescription of obligation. That is where the rule of law comes in. So we in Africa, as I've said before, have chosen to have a form of government, representative government, under the Constitution, under the constitutions, which in many instances is constitutional democracy. Constitutional democracy. Constitutional democracy translates into all the laws that comply with the Constitution. So there is one legal system, really, that sets the standard, and all other legal prescriptions comply with that. Once we agree that that is the case, then we all submit to the supremacy of the Constitution. All those who either are institutions that run elections, either they are judges that make decisions, hear and determine cases that come before them, the electoral disputes, those who participate in the constitutional process, the electoral process, all those are subject to one thing. And they are subject to an objective standard wherever they are. They must do not what they want, not what is arbitrary. They must do that which is allowed by the principles of constitutionalism, the principles of the law, whether it's a statute law, the Electoral Act, or is the Constitution itself providing directly. They must comply. Now, if that is correct, there is no election outside the law. There is no election outside the law. There is no democracy outside the law. That's why we heard correctly that elections don't necessarily coincide with democracy. It's a much bigger concept of a system of government chosen by the people deliberately at a moment, at a specific moment. And quite often, democratic institutions are chosen deliberately because not every government is a democratic government. So there must be a choice of this form of government, democracy. There are others, autocracy, dictatorship. There are forms of government. Let's not forget that. There are forms of government. So when we people choose at a particular moment, and in many cases, is at the time of making of the Constitution, they choose the specific type of government, a specific system of governance, the representative system of governance. But there are principles there. And all those principles are embodied in the Constitution. The constitutions prescribe those principles that need to be complied with. But all institutions that have anything to do with maintenance, establishment, maintenance, and realization of this form of governance to ensure good governance. Good governance. All these principles. Now, the fundamental principle there is that everything we talk about today is legally provided for. I want it to be clear. Everything we talk about are concepts of law. They are legally provided concepts. You cannot talk of democracy, you can't talk of election, you can't talk of human rights, you can't talk of whatever you think of that has this binding element without the law. So it is the law that prescribes the acts. It is the law that prescribes the form and prescribes the acts that it needs to be done. And it also prescribes the very standards by which you must be measured, or you must measure others to say whether there has been conformity or not. So that at the end of the day, you too can be measured. The citizen can measure and say, has this process been done accordingly, according to law? Has everything that was required been done according to law? That is where the element of fairness comes in. You must judge people fairly. You can only judge me fairly if you subject me to an objective standard of assessment. You cannot be judging me fairly if you judge me because of your own personal interests. That's why you find that there are problems where judges are subjected to threats. A lot of threats, unnecessary threats, simply because those who do so don't understand that whatever criticism they would want to make of a judicial officer, it must be a constructive criticism. What do we mean constructive criticism? It's a criticism that is a reference to a standard of conduct by a judicial officer in a particular case. Not as a criticism that arises from the fact that the judicial officer has done what that person wanted. So you find that when the criticism comes in, no one is bothering about analyzing objectively because they just don't apply the standard. So it's important for us. It's very important for the judiciary all over to understand that the terrain of the judiciary is the rule of law. The safety of the judiciary is in the rule of law. And that simply means being in a position to make an independent decision on the facts of the case that you have found, to which you then apply the law. The law, I have said again, that very important prescription. The law, the principles of that law, as you have interpreted that law. That is why it is in the domain of the judiciary, no one else. It is in the domain, exclusive domain. This is a very important principle. It's in the exclusive domain of the judiciary to interpret the law and apply it to the facts found. But the rule of law is an all-encompassing principle. As I said, it's a fundamental constitutional principle. It is a principle that drives all these processes. We talk about democracy, good governance. They are maintained, they are acquired by compliance with the law. So the rule of law is not binding only on the judiciary. It's binding on everyone. That is why we talk of electoral processes. That is why we're talking of electoral processes. When we talk of electoral processes, we are talking of legally defined processes of activity. And those activities are juristic activities. Understand me. They are juristic activities. They're not any activity They are activities that have been deliberately chosen to fit that moment and prescription and definition for a purpose. So you have an activity of great importance, for example, the vote. You are voting. That's an activity. It's an activity on its own. Think for a moment. Don't think of it as a right. Think of it for a moment. It's an activity. Campaigning is an activity. Association, associate with others, assemble with others. Those are activities. But look at it. They are activities of a specific nature. How many times do we associate with our girlfriends? Many times. How many times do we associate with our boyfriends? Many times. But is that electoral association? It is not. Because the law is not concerned with that association. That is a private association. It is of no concern to the public office. It's no concern to the means by which it chooses, the means that it chooses to define as important, relevant activities. So that if those activities are done according to the law, they are the only activities that will ensure access to the levers of power of the state. That's what the law says. And those are the only activities the law then grants rights. It grants rights in respect of that activity. You must vote. There must be a vote. That voter must be allowed into a ballot, what they call them, polling station. When the person gets to a polling station, there should be no one nearby to intimidate that person. That person must feel free. And that person must go in there and find those who are in charge of the process of administering that vote. And that person must be free. For that moment, that person is the king. That's what the law says. That person is a king. That person has a right to go in there, do what he or she does, and go into the ballot box on his or her own in privacy. They call it secret. I don't know. It's called secret. Yeah. The law says it's secret. He or she must go into that ballot, into that booth in secrecy and put the X of choice, electing the person to get into public office, not private office. You can see now, the law is not concerned about private office, because being in a private office can also be involved election. But we're not concerned about that. The law we're talking about is election process that leads to access into a public office, into power. Now, we begin to see that in principle, we must comply with certain things about this vote. It can't just be an ordinary vote. It cannot be an ordinary vote because it is constitutionally provided for. It is constitutionally provided for It may be statutorily provided for in the Electoral Act. But we must accept, in principle, the fundamental principle is that it's not an ordinary vote. It's a vote into an office, a public office. Therefore, I say, no, the Constitution says, it must be free. It must be fair. It must be in peace. That is that vote. So when we look at it, it's not just that vote. We now look at the whole process leading up to that vote as a matter of right now. The law gives these activities the right part. Why do we want the law to do so? The law gives those activities because it wants to impose obligations on others. It wants to impose duties on other people. It wants to guarantee this right so that it is done properly and provide for the ultimate right. It must be therefore a free, peaceful, free, fair election. Peaceful, free, fair election. This principle is a constitutionally provided principle. So if we comply with that and produce that result, produce that process, we have complied with the Constitution. If we do that as a matter of course, as a culture, we comply with constitutionalism. We are complying with the Constitution, the dictates of the Constitution. We are conscious of the obligation on all institutions to do so. We are upholding the rule of law. But you can see, it's not, I haven't got to the judge yet. We are still with the bodies that administer that process. The electoral commissions. Once they understand, and they do most of the time, that they have the compliance with those dictates, they adhere to they strictly adhere and enforce that law. Understanding that it is interpreted in the circumstances of the case. That is the fairness part. Then I can tell you here that we should not have, we should not have people winning or seeking to win elections through courts. We should not have people seeking to win elections through courts. Unfortunately, that is what is happening. Because once those bodies have done their job properly, and they do, we as people who would benefit from that result of a free, fair election should be in a position to say, yes, that's a result. But what is happening in Africa most of the time? You heard what the rankings of popularity were showing. It's that people just think that a free and fair election is one where they win. When they don't win, of course, you have a right. If you have good grounds for challenging the election. But the law says very clearly, there's a presumption of constitutionality in every election. You don't start an election from presuming that it is not free, fair. You start from saying it is an election that went through in terms of the law. And therefore, the person who is challenging that election will obviously have to show grounds That is the point. A person has to show it may be a question of difference of the standard, but I tell you, the bottom line is there is a presumption of constitutionality in every election. Otherwise, if we didn't have presumption of constitutionality, there will always be challenges in courts. There will always be challenges. We must start from a presumption of constitutionality. And then we must have to look at the particular facts, apply the rule of law, and uphold electoral justice. But electoral justice, as I define it, is broader than that appearance in court. Electoral justice starts with things being done properly in terms of the rule of law. This is what electoral justice is. We cannot abrogate. I know we may narrow it to judges, but that's not what it is about. Electoral justice means that people are happy with what has happened and has produced this body of people who will govern. They will not only govern for you who voted for them. That's not what the purpose of an election is. The purpose of an election is to put in a government for everybody. Because democracy is a form of government of the people, by the people, for the people. Once you get in there, you cannot say, I have been voted by so-and-so in my constituency, who may be a very small minority. And therefore, I'm going to think about them and invite them for a cup of tea every weekend because they voted for me. No. You forget about them and say there must be a road here to benefit everybody. And therefore, I think it's important for us, I think my time is up, that we understand that whatever we're doing, elections are governed by the law. And if they are governed by the law, there will always be the judiciary. You cannot have a system of law without a judiciary. If there is a need for enforcement, upholdment of a rule of law, you will always need a judiciary. And you will always need an independent judiciary because it is the essence of the rule of law. So it's not surprising that we are there as judiciaries. The question is, are we conscious that we are so important and effective a force in the determination of good governance? I think as judiciaries, we have not gotten there yet, that we are part and parcel of that structure that is maintaining and ensuring good governance. So our decisions must also have that consciousness of the effect, the consciousness of their effect. Of course, they must remain judicial decisions, but obviously they will have political effects. They remain judicial decisions, but they have political effect. But the bottom line, the fundamental principle of constitutionalism is we must be able to use all these essences and our offices, our powers to ensure good governance. Anyway, I thank you for now. Thank you.
Let's give Justice Malaba another round of applause, please. He said so many things, so many important points. And I think that being a moderator always comes with it. The temptation of sneaking in one's own presentation under the guise of summarizing a presentation. I want to avoid that temptation now and want to go straight into the next segment of this session, namely the panel discussion. And the topic for the panel discussion is building blocks for good constitutional governance and fundamentals and principles of electoral justice, perspectives from practice and experience. And to deal with this important topic, we have two panelists. One is Honorable Justice Isaac Lenola of Kenya, who is joining us virtually. His bio is in the brochure, so I'll not bother to read out his very rich profile. And the next presenter is Ambassador Saleh Ahmad from South Sudan. He is the head of the African Governance Architecture Secretariat at the African Union. He too has his bio set out in the brochure, and I will not dare read it. I think both these panelists are joining us virtually, and so we shall now ask our colleagues to help us with the technical bits to get to these colleagues. So we welcome Justice Isaac Lenola of Kenya. Judge, welcome to the session, and please proceed with your presentation. Please unmute your.
Thank you very much, Master of Ceremonies, and good afternoon from Nairobi. I hope you can hear me. I followed the proceedings since morning, so let me begin by acknowledging the presence of the Chief Justices present, my lords and ladies, judges, distinguished ladies and gentlemen. Let me also adopt the protocols read this morning by Mr. Chikwana so that I can save on time. First, I would like to thank the previous presenters. I've sat through the morning presentations, and it's obvious to me that a lot of what I was going to say has been said by way of introduction, and therefore, the beginning of my paper will have to change, and I will only say the following by way of introduction. The first issue is that good governance, rule of law, electoral justice are truly cornerstones of any democracy in the context of what my lords have said earlier. And we also know that the framework for ensuring protection of rights, limits of separation of powers, and transparent governance must arise from the basis of a constitution, as my Lord Malaba has said. And so legitimate government is the foundation upon which all elections are to be conducted in the context of Africa, for example. I will not go into definitions. I will not go into the meaning of electoral justice, but I'll go straight to what our constitution in Kenya, because my context is a Kenyan constitution. The Kenyan constitution embodies all these principles and also creates key institutions relevant to ensure effective electoral justice. And again, my Lord Malaba has spoken to the role of the electoral management body and the courts. But more fundamentally, I think that the right to political participation and the creation of structures and systems that guarantee equitable distribution of justice, democracy, and accountability are important in a country such as ours. Later, when I focus on the courts, I will specifically focus on my court, the Supreme Court of Kenya, which is the apex court in this country, and which deals specifically with the determination of election petitions relating to the election of the president. I will not touch on the African Charter on Democracy, Elections and Governance, because Dr. Malosa has already done that. Having then said that, so far as I know, any effective electoral justice system has three phases: the pre-electoral phase, the electoral phase, and the post-electoral phase. We in court, obviously, are involved ultimately in every phase. And tomorrow or today, I think tomorrow, my brother Mohammed Ibrahim will speak on the pre-election preparedness protocols that the Kenya judiciary has undertaken quite successfully in the last 3 elections. Coming to Kenya specifically, it is no longer debated, and I see that my friend Don Dare is here. It's no longer debated that the Kenyan electoral system prior to 2010 was thoroughly ineffective. And the elections between 1992 and the year 2002 were rife with injustices sometimes committed by we in the judiciary. And this is because our judiciary in that period and prior to that period were either too timid, and I'm being candid and honest here, were either too timid to fairly determine disputes, or decided to hide behind technicalities of law to dismiss election petitions. When Judge Maraga and my Lord Maraga, you remember this, when we joined the judiciary of Kenya in the year 2003, one of the difficulties we found was resolution of disputes and precedents where every 3/4 of election petitions were being dismissed because of lack of service on the respondents who are either members of parliament or the president or whoever else. And so a lot of time was spent hearing technicalities and determining matters on technicalities. And that lesson is a big lesson as to what later became what I consider myself a more realistic, a more fair, a more just dispute resolution framework, which we are now enjoying in our country. The fact that courts were timid, or the courts were perceived to be pro-executive, is precisely what led to the events of the general election of 2007. You will recall that in 2007, 2008, Kenya was embroiled in post-election violence, and one of the reasons given by the opposition for going to the streets and seeking people justice as opposed to judicial justice was the rallying call that the opposition would not receive justice, electoral justice, in the Kenyan courts as then constituted. And I submit to you that the pain that Kenya underwent throughout that period is one that I would not wish on any African state, or indeed any state in the world. The violence was beyond any measure that any country should ever have. And so the events of that election fast-tracked the promulgation of a new constitution for Kenya, which had begun in 1990, but was only attained and achieved in 2010. And so that period, the period post-2010, is crucial in terms of what I'm going to say next. Because of the lessons of the period prior to 2010, the fear that courts were not granting justice to persons that came to them seeking electoral justice, we created a constitution that is very big and very deep on electoral justice. And I'll speak to 3 issues. The first is the role of legislation to govern elections and to ensure that parties that approach courts to seek electoral justice do get that justice. And so Article 82 of the Constitution of Kenya provides that Parliament must enact legislation to ensure that the Electoral Boundaries Commission delimits electoral units for the National Assembly and county assemblies to ensure that there is fairness in how people vote. Number 2, the process of nomination of candidates would be fair. Number 3, that voters are continuously registered. Number 4, that administration of elections and referenda is a mandate given to the electoral management body. And more fundamentally, something that happened before was the continuous registration of citizens residing outside Kenya and the progressive realization of the rights to vote. And I wrote a judgment in 2013 where I gave the parameters for the progressive realization of this right by the diaspora to vote in Kenya. But electoral laws, those electoral laws then were enacted as the Elections Act, the Independent Electoral Boundaries Commissions Act 2011, Political Parties Act, the Election Offences Act, and the Election Campaign Financing Act. Because all these issues that these laws address are important for any electoral justice to be attained. But the Constitution also goes further to say that the essential features of any electoral justice in Kenya must have the following rights: the right to form or participate in forming a political party, to participate in the activities of a political party, or to campaign for a political party or cause. And that adult citizens must have the right without unreasonable restrictions to be registered as voters, to vote for in a secret ballot, and to be candidates for public office. The same Constitution then enumerates certain principles that this, and that's the second point, that the electoral system must comply with. And these are in Article 81. They are, you must express your rights under Article 38. Not more than 2/3 of members of any elective body shall be of the same gender. That persons with disabilities are fairly represented. There is universal suffrage on the aspiration for fair representation and equality of vote, and fair and free elections which are by secret ballot, free from violence, intimidation, improper influence or corruption. And this is born of the history of Kenya during elections, conducted by independent body, and are transparent and administered in an impartial, neutral, efficient, accurate, and accountable manner. These principles are the principles that we in the courts are obligated to ensure that they are upheld. I will jump the role of the electoral body because previous speakers have spoken to it, but let me now jump straight to the courts. The court in Article 159, the Constitution Article 159 says that judicial authority is vested by the people on the courts of Kenya. And I will limit myself in that regard to the Supreme Court. Under Article 140 of the Constitution, the Supreme Court of Kenya is a body mandated to determine disputes relating to presidential election petitions. The other courts deal with other elections. And as I now speak to our experiences as Kenyans, I must say that Article 140 says within 7 days of the date of the declaration of the results of the presidential election, then anyone can petition the court seeking nullification of that election. And in doing so, the court then is required to follow the tenets laid down in the Constitution. But at this point, I must speak to a reality that we in Kenya, and Justice Maraga, and speak to it also, around the period by which we are to determine these heavily contested disputes. So you file the petition within 7 days of the declaration, and the courts must the filing, the hearing, and the determination must be done within 14 days. And that has been a very difficult experience for any of us who are sat at the Supreme Court. I know some countries don't have a period. Some countries like Tanzania don't even have a procedure for challenging presidential election petitions, elections. Other countries have a year. Our courts, the High Court, Court of Appeal, have 6 months. The Supreme Court has 14 days. And I think there will be a question as to whether real justice can be given by the courts in such a constrained period. The other issue, another experience which I think I should share with you, which was touched on by, I believe, one of the prior speakers, is a question of technology in courts. And I think one of the speakers touched on the double-edged nature of technology, but I'll speak to the technology as integrated into the Kenyan electoral system. In Kenya, there is a biometric voter registration system, electronic voter identification, and electronic transmission of results under Section 44 of the Elections Act. The Kenyan system is unique, as I guess other systems are also unique. You will all remember, those who have read, and I see my friend Alex Owor is with you. In Kenya, Section 39(1)(c) of the Elections Act says the commission, the Independent Electoral Boundaries Commission, shall electronically transmit in the prescribed form the tabulated results on election for every polling station to the constituency tallying center and to the national tallying center. So that the Kenyan system, while it's hybrid, transmission is specifically for presidential election petition cases transmitted electronically. And those who have read the 2017 presidential election petition judgment headed by Justice Maraga, in which I sat, you will remember that the main reason for which the court nullified the election was the problem with transmission of election results. And this is what we said in that case, that where the electoral body fails to transmit almost 11,000 results, polling station results to the National Tallying Center, then announces the final results, there's something wrong, and therefore the election is won for nullification, because it is not verifiable, it is not transparent, it is not accountable. So I'm sure there are questions whether we, in the Kenyan context, have raised electronic transmission to a level that ought not to be. But we are certain ourselves that once it is a necessity of the law, then we must enforce the law as it is. It is interesting, in my view, to note that prior to 2013, 2017, and 2022, the grounds for nullification of election results in Kenya were mainly violence, bribery, and strange grounds like witchcraft. Today, technology is at the center of any electoral justice in Kenya. And therefore, I think it is a point of debate moving forward. The second practical question that I would like to place on the table for your consideration is the big debate around the standard and burden proof. What is the standard? What is the burden? The burden is easier because everyone says he who alleges non-compliance with electoral law must prove that that burden, has that burden. What about the standard? Some jurisdictions say it's a civil case like any other. Others are saying, well, it's a criminal, there's a criminal element like bribery, then it's beyond reasonable doubt. If it is not, then it's somewhere below reasonable doubt and above preponderance of evidence. We have taken that latter position, that once you prove it, it is below a reasonable doubt, but above balance of probabilities. But I also need, as a third practical point, to then address another issue, which has come to the fore in Kenya, which is the shifting of the burden of proof. I've read some commentary saying that the Kenyan 2017 Raila decision and the 2022 Raila versus Ruto decision shifted the burden far too much on the Electoral Commission. But there was a reason for us to do that. And I said earlier that in 2017, we were confronted with a situation where the Electoral Commission, without receiving results from 11,883 polling stations and 17 constituency tallying centers, and having not received authentic Forms 34A from 5,015 polling stations, representing up to 3.5 million voters, nonetheless declared the final result of the election. And what we said in the petition was, bearing in mind that IEBC had the custody of the record of elections, the burden shifted to it the moment a question was raised as to the authenticity of the results it had published. And so it had a duty. The burden shifted to it had a duty to show that the results it released and the records in its custody fell above the standard expected by the law. And that was basically the reason why in 2017, we nullified the election. And so the burden of proof and shifting of it is a reality question that we could discuss as we go along. In 2022, We said this again on the same point. Suffice to stress that the court has been consistent that a petitioner who seeks nullification of election and says it's not in conformity to the constitution of the law has the duty to prove that ground. But once he has done that and discharged that burden, then the evidentiary burden shifts the respondent, who in this case is the commission. I would like to then raise four other issues of a practical nature. My paper is quite detailed, but I'm jumping a lot of issues because one, of time, and two, my friend Arnold Sunga knows my difficulties this morning because I prepared to speak yesterday and not today, so my day is not as good as ought to be. Let me then raise the following other issues. On the time frame for settling disputes, I spoke earlier about the 14 days. In the case of Mother Karua versus Anne Waiguru, an election petition regarding the governor's election for one of the counties in Kenya. Although I said earlier, the other courts, the High Court and the Court of Appeal, have 6 months to determine the petitions. In the Karua case, the matter went to the Court of Appeal on a preliminary question because it was struck out. The Court of Appeal said, no, it ought not to have been struck out. Here, the petition on the merits. It went back to the High Court. The High Court delivered a decision on the merits 1 day before the period of 6 months had expired. So by the time the matter went to the Court of Appeal, the Court of Appeal's period for hearing the matter had expired. And the Court of Appeal struck out the petition, and that order was upheld by the Supreme Court. The Honorable Karua went to the East African Court of Justice, and it was found that the Supreme Court of Kenya did not give her the right to fair hearing by not hearing her petition on the merits. That issue is out there. How do we manage timelines created by statutes and the workload of courts and the question whether these timelines should remove from the courts the ability to hear the matter on the merits at all times? The second issue, as I go to the end, is respect for electoral court decisions. I think a month or so ago, I did read something from Zimbabwe about the judiciary complaining that there is no respect for decisions arising out of courts during the electoral period. If Zimbabwe has felt the heat, Kenya is still feeling the heat since 2022. We have struggled with insults as courts, as judges individually, and I'll speak shortly about social media. I think we need to find a way of ensuring that those who lose election petitions do respect the decisions of those courts and use the appeal mechanism where there is to challenge these decisions. There cannot be justice only if a party wins. Electoral justice is not always when a specific party wins, whether it's the government side or the opposition side. I think we need to have that conversation as judiciaries. But speaking to ourselves as judges, I think we need to also introspect. My Lord Malaba touched on it earlier. We need to ensure that our decisional independence is beyond reproach, and it should never be challenged or qualified. And I'm saying this because why was it shocking to the world that the Kenyan Supreme Court and the Malawian courts nullified the presidential elections? It is because, like the proverbial chicken that even after being released is unable to walk, the average African cannot see how anyone can tell a sitting president, you did not win an election, like Kenya and Malawi did. But I submit to you that we as judges, we as courts, must never be shy to do what the law tells us to do. I have spoken before and said Article 140 of the Constitution of Kenya tells the Supreme Court, should you find irregularities and illegalities in the presidential election, nullified. And that's what we did in 2017, led by Chief Justice Maraga. Why should we be timid when the law is on our side? Let me speak now to the place of social media in electoral contests. Dr. Malosa spoke about it and said that social media has its role. But speaking from the Kenyan experience, social media has been used to actually damage the reputation of judges sitting in these electoral courts. And we cannot at every instance go to our own courts to seek justice ourselves. But society must appreciate the fact that we have this difficult duty to undertake, but that should not attract insults to our families, insults to ourselves, insults to the court, and the dignity of the court and the justice system. The Supreme Court of Kenya, as you know, is going through a very difficult time because of an advocate whose duty it has been for the 11 years since the court was created, has taken to social media on every single morning to insult judges because of their decisions and for whatever other reason. I think we need, as judiciaries, to discuss social media and perhaps create guidelines on the management of social media by counsel especially and by other parties appearing before us. Otherwise, if we allow the dignity of courts and judges to be tarnished out there, the next thing will be the very likely event of people deliberately disobeying court orders, because who cares about courts anyway? We insult them in social media. What can they do? And so let me close by saying this. I thank you very much for inviting me to speak in this forum. I'm sorry the time has been short, but I hope that later in the conversation at plenary, we can give answers some of the questions that I posed and some of the questions that other speakers have posed. We at a place in Africa where we must get together periodically like you've done in this meeting to ensure that our standards are the same across Africa in terms of management of electoral disputes, and that the sounds of happiness by Africans on the amazing work we are doing in ensuring that electoral justice is enjoyed by every African citizen is indeed a reality in days to come. And this conversation must continue beyond here. And I thank my colleagues at AJJF for being partners in this engagement. I thank the Judiciary of Zimbabwe for inviting me. Sorry, I could not come in person, but I hope I put something on the table which will have justified my presence in beautiful Victoria Falls. I thank you very much for listening to me.
Thank you very much, Justice. Yes, thank you very much, Justice Leonola, for that very enlightening presentation. I think he deserves a bigger round of applause. It is indeed an enlightening presentation, and I am sure you have a lot of questions and a lot of discussion points to bring forth during the plenary. For now, we shall go straight on to the next panelist, Ambassador Salah Ahmed of South Sudan. Okay, I'm advised that we have a slight problem with the panelists joining us. So what we shall do now is to get into plenary, raise the issues, questions, discussions, and then when he is ready, we may have to interrupt the plenary and get his presentation and proceed that way. Okay? Right, so the floor is now open for those of you that have any questions, comments, contributions, to raise them. And you can either address them to Justice Malava here or to Justice Lenola, who I believe is still online and ready to take your questions. So we'll start with the first a round of three questions. The first round of three questions. Any takers? Yes, I see a hand over there. Please just introduce yourself again before you pose your question. And remember to keep your contributions short and tidy.
Yes, my name is Chinembiri Energy Bonu, a judge of the Supreme Court of Zimbabwe. My question is, where a government has strayed from the principles of constitutionalism, good governance, and electoral justice, is it permissible for the people to use other means for changing government? I direct the question to our Chief Justice.
Thank you very much. Any other contribution, question? Yes, I see a hand here. Is that Justice Mangota?
Thank you, Chair. I'm David Mangota, Judge of the High Court, Zimbabwe. I must start by commending the presenters. It was clear, lucid, and the point. We enjoyed every bit of what they put across to us. I'm aware that we may challenge as judges with social media, especially where you deliver a judgment, and somebody's not happy with it, and social media as a meal of it. And I think Judge Leonola made mention of this one. What can we as judges do to ensure that we minimize the damage of attacking judges who have done their work objectively? I thank you.
Thank you, Justice Mangota. Last question this round. Yes, the judge from South Africa.
Thank you. It's Dumisani Zondi from South Africa. This question is directed to Judge Leonola of Kenya. It's regarding the standard of proof in where there is a challenge on the presidential election result. What extent do you take into account the fact that if the electoral body has done whatever it's necessary to be done, that should be counted in its favor in the consideration of whether or not the onus of proof has been discharged? Because I understand that the onus of proof obviously is on the petitioner, and then the evidential burden will shift as the case progresses. So that is my question.
Right, thank you very much. I think we'll get our presenters to respond to those three questions. I think there are two questions directed to Justice Denaola, one on social media and the other one on burden of proof, or is
Okay.
it the standard of proof rather?
And standard of proof.
Start with,
Thank you very much.
Justice,
Let me begin with,
Denaola, and then
yes,
the one question directed at Chief Justice Malaba will be answered later.
okay. Thank
Justice,
you. Judge Nembiri,
Denaola?
the question is to the Chief Justice, so I'll not answer that. But let me answer my brother and Chairman Chinengo. In 2017, one of the issues that came up in the petition was the issue of verifiability of results. And I'm just saying, I said in my presentation that the reason we found the election not to be verifiable was because the Kenyan process is we have the physical forms 34A, and then we have the transmitted forms. Then you verify the physical against the electronic. And we could not find in many cases the meeting of results. And that's why we said we could not verify the results. He also asked the question about media relations in Kenya, whether we have a media relations person in Kenya. We do not have a spokesperson, and so sometimes the Chief Justice speaks, sometimes the Chief Registrar speaks. We release statements from the Media Directorate of the Communication Directorate of Kenya. I chair the Committee on Communication, and we are now having a conversation around whether we should have a standby full-time media relations person to address issues that come out of our decisions. Let me tie that with Justice Mangota's question on social media. I have asked this question across other jurisdictions. I think the only credible answer I got in managing social media is to create social media guidelines in consultation with the law societies. Some years ago, the Law Society of Kenya attempted to draft social media guidelines, but they were shot down at the level of the Council of the Law Society. But we are now beginning a conversation to say, let us have guidelines that are acceptable to the lawyers, acceptable to us, without breaching the right to express yourself. So I think for me, that is one way of doing it. The other way, so that we stop misreporting, especially in social media, is in cases that are of public nature, including election petition judgments, let us have media summaries. Media summaries have worked well for us. Every time we issue a media summary together with the judgment, the media summary summarizes the salient points to the media, including social media, and it's easier to have the facts and the law and the decision disseminated out there, and misinterpretation is then minimized. As to the insults, the denigration, the bad-mouthing, I think this would be handled on a case-to-case basis. But I think if we have guidelines, then it's easier to punish, especially counsel who breach the guidelines. On the question of standard of proof and where the Electoral Commission has conducted itself in a proper manner, we had this experience in 2017. In the first election, which we nullified, the Electoral Commission, in our view, had certainly gone way out of its mandate and completely failed. And we say so in the judgment. And we pointed out the elements of failure. When we sent the country back to a repeat election in October of 2022, and the second petition came to us that same year, we were able to tell the commission that, look, we have seen the complaints by the petitioners, we have seen your response. It is the petitioners who have been unable to prove their case to the required standard because your answers are sufficient to answer the complaint. So we didn't even shift the burden of proof to them. But even if we had shifted the burden of proof to them, they were able to prove quite properly that they conducted the second election very, very fairly, and they learned from the lessons of the August 1st election of 2017. Similarly, in 2022, we could not fault the commission. And what I noted myself is that our colleagues who had filed the petition used a lot of the material that they had used in 2017. In fact, one of the most amazing things was we found that some of the electronic material used in 2017 was given to us in the 2022 petition. So obviously the petitioners themselves had failed to prove their case to the required standard. I sat in Zimbabwe during the 2018 election petition at the Supreme Court. And looking at the petition presented to the Zimbabwean Supreme Court and the petition presented to Kenya in 2017, it was a cut and paste job. They used the Kenyan petition to change a few things and they presented to the Zimbabwean Supreme Court. So where parties file petitions without much evidence, then of course the courts will have no choice but to dismiss it for falling far below the standard of proof. Those are the questions posed to me. I thank you very much.
Thank you very much for those responses. Chief Justice.
Thank you. I just want to answer one question. When government does not act in terms of the principle of constitutionalism, what can people do? Are there other steps which people can take? I think it's a broad question, but I can answer it like this. Constitutionalism, by definition, is enforcement of the constitutional provisions, the principles. It's a way of life. The Constitution speaks all the time. And so it means that government, even all institutions really, including what we call government, because government is a broader term, including many institutions that enforce powers, exercise powers of governance at different levels. So when we talk of governance, really we should understand that it's a broad legal term. So in there are remedies provided for, so that there cannot be a time where there can be any thought of extra legal remedies outside the law. So it means that wherever there is a violation, whether it's of a right or a breach of duty under the Constitution, there is a remedy. And the obligation on us, and whoever wants to take a case to court, is to find that remedy and frame it as a source of a cause of action, so that the Constitution then is enforced against the breach. So constitutionalism does not necessarily deal with the positive aspect, the enforcement of the correct things. It also involves enforcement of remedies against wrongs. So I think that is precisely what constitutionalism is about, is being able to attack the remedies, attack the wrongs, and so that you protect the rights and enforce them. And if it's against government, so be it. But I can't think of any other steps outside the law. We would otherwise encouraging self-help, which we shouldn't be talking about here. We are all judges and judicial people, bodies that enforce the law. As I said, the rule of law is applicable to everybody, and that is what it is. I hope I've answered the question. Thank you.
Thank you very much, Chief Justice, for that response. Let's take the second round of questions. Yes, I see a hand over there. And another one over there. And another one here. Seems it's just the ladies' round, yeah?
Thank you very much, moderator, and for allowing me the opportunity to speak. Mine is not a question, it's more for comment. I was listening when the Honorable Chief Justice of Zimbabwe—
Going to tell us your name and your position?
My name is Justice Priscilla Makanyara Chigumba. I'm a judge of the High Court of Zimbabwe based at Harare and the chairperson of the Zimbabwe Electoral Commission. I don't have a question, I have a comment. Is that permissible? Yes? May I proceed?
Yes, please.
Thank you. I was listening to what the judge from the Kenyan Supreme Court said about the fact that judges should not necessarily dismiss electoral petitions on technicalities, that judges should consider actually dealing with matters on the merits. And that's a very valid and interesting point. I also took note of what our Chief Justice said on what constitutes constitutionalism and how that dovetails with electoral justice. My concern is a bit of a provocative one, but I'm going to go there anyway, hopefully to provoke some more debate. My concern is that it appears to have become fashionable in Africa to use the constitution and the law as a sword under the guise of the pursuit of electoral justice. And this happens, in my observation and my personal view, across both sides of the political divide. You will find that during an election, the law will be used, for want of a better expression, as a campaign tool, really, to one-up each other. Some have coined this phenomena lawfare here in Zimbabwe. And what I would like to challenge all of us here to think about is, what are the mechanisms that we can use to curb such abuse of court process without necessarily violating anyone's constitutional rights, without necessarily dismissing matters on technicalities, and without necessarily placing unrealistic burdens on EMBs and on the courts. What I would like to urge is that in coming up with the outputs of this symposium and in coming up with our continental best practices and regulatory reform initiatives in the filing and adjudication of electoral disputes, we very carefully set an unattainable standard, a continental standard, which is attainable and which we can all adhere to. Thank you. That's my comment.
Thank you very much for that comment. Who was next? Someone at the back? Yes.
Good afternoon, everyone. And thank you, Chair, for the opportunity to speak. I would like to begin by quoting the Chief Justice.
Are you going to tell us your name and your position?
My name is Tatenda Mazarura. I'm from Crisis in Zimbabwe Coalition. I would like to begin by quoting Chief Justice Malaba. One of his concluding remarks was, electoral justice starts with things being done properly in terms of the law, ensuring that people are happy with both the process and the outcome. I sit here today representing more than 4 million Zimbabweans living and working outside Zimbabwe, whose right to vote remains a pipeline dream. This is despite Section 67, which provides that every Zimbabwean who's 18 years or older is able to vote. This right to vote is actually guaranteed by the Constitution, but the Electoral Act does not actually allow those in the diaspora, except for those on national duty. So it limits this right to vote for us diasporans. So my question is, do I cease to become a Zimbabwean citizen because I've been pushed by economic and political stability, amongst other factors, to live and work outside the country? I will conclude by saying that in 2013 and 2017, we had cases that were brought to the Court, but they were dismissed by the judges who argued that the right to vote for Zimbabweans in the diaspora is limited to those on national duty. So my question is there a way that can judges our laws to ensure that there is inclusion and to ensure that we do not disenfranchise an important demography and some of our citizens? Thank you.
Thank you very much for that question. I think I'll take the two of you because one was just a comment. Yes. Is that Justice Makarau?
Makarau, yes, thank you.
Yes.
My name is Rita Makarau. I'm a judge with the Constitutional Court of Zimbabwe. I want to start off by adding my voice to Justice Mangota for the two presentations, very inspiring and very thought-provoking. I'm not going to ask a question, but maybe my comment is to voice an issue that has always exercised my mind relating to election petitions, and to ask that, is it the best form of proceedings that we can have? Well, in Zimbabwe, election petitions come by way of a petition accompanied by affidavits. Sometimes you get 80 affidavits all saying the same thing, cut and paste. You just change the name of the deponent, but they are all attesting to the same event. I'm aware that because of the time frame, there may be no room for us to hear evidence and to have the deponents cross-examined. But as a way of maybe reforming the law, is there no other procedure that we can adopt? We are rendering a decision on a very important issue after considering affidavits, and in a very short space of time. And it's an issue that has always exercised my mind and say, is that the best way of dealing with such an issue? Simple divorces, I hear, if you have a evidence, I take 6 months to decide. Election petition, the election of a president, 14 days, affidavits, and you've got to render a decision. Thank you.
Thank you very much, Judge, for that comment, stroke question. We'll come to you, Justice Lombepiri. Let's just get a question from someone online. Monica Doba.
I would like to appreciate the presentation of both justices, my Lord Justice, the Chief Justice of Zimbabwe and the Justice of the Supreme Court of Kenya. My question to the Honorable the Chief Justice is on the rule of law. How do you determine the happiness of the majority of the people in an election where there is a possibility of masses or crowd being hired? And what particularly would be an example of the rule of law being complied with? Would it be requirement of pre-election, like the process of conducting internal election processes, within the party? Or will it be, when it is within the party, it's restricted to the members of the party? Now, when it becomes a general election, there could be people who are not members of the party who are affected by the conduct of the election and the inaction of action of the members of a party to which they are not subscribed. Then by my Lord Justice Isaac, sorry I used your first name. Is it possible, are there situations where pre-election matters dovetail to post-election matters? Or are all pre-election matters determined before election, and once election has taken place, those matters do not come to, are not applicable and relevant to post-election matters? Thank you very much, Mr. Chair.
Thank you. Thank you so much for that question. We'll now close this round with a question from Justice Lombe.
I am Judge Lombe Piri. I'm the judge in charge for the Livingston High Court in Zambia. My question is to Justice Lenaola from Kenya. You spoke about a case where the East African Court of Justice overturned the decision of the Kenyan Supreme Court on an issue of timelines. And I think you said the time had expired in the matter, and they said the petition had to be heard again. So they overturned the decision of the Kenyan Supreme Court. I just want to understand on what basis was this done, especially if these timelines are prescribed by law, because I know in Zambia they're very strict about timelines. So what basis did they give? What mode of interpretation was used? Thank you.
Thank you very much for that question. I'll give the floor now to Justice Lenaola to respond to some of those concerns and questions, especially those that were directed at you.
Well, thank you very much for the questions. Just one word for Justice Makanyara. I agree with you that we must continue the conversation around misuse of the courts to achieve political ends by parties that are using the Constitution to achieve ends that are just nefarious, not really anything to do with seeking justice. It's a question we are dealing with here, and it will not end soon. Lady Justice Masarura, the question of diaspora vote, just from the Kenyan experience. Like I said, in 2013, I wrote a judgment while at the High Court in Jaffa Kanu versus IEBC, where I gave what I consider to be a reasonable provision for the Commission to allow diaspora votes, because I think we share the same provision of the Constitution. And now we have voters in Kenya voting from the diaspora, not in all places, but where there is a sizable population of Kenyans. So we have sort of moved away from that crisis, unlike Zimbabwe, from what I gather. Justice Makarao, again, you're right. Like I said in my presentation, it's quite difficult to appreciate how a court can do justice if the period to do all these things is so limited. In 2013, the Kenyan Supreme Court, then headed by Chief Justice Mutunga, struck out the petitioner's affidavit, which they said contained the entire substance of the evidence to prove the petition. And it has been one of those things that is haunting the court. You know, could we have done better with that or not? But again, with the time frame, not able to take oral evidence, what can the courts do while the Constitution is that strict? So it's an issue, again, each country must grapple with and find a way using their laws. Monica Dongban Mesem, the question about pre-election matters is also an issue that we have addressed in the Kenyan context. In the 2017 election cycle, we had to struggle with that question. And what happened was, and the candidate for the position of governor went through the pre-election motions regarding his qualification, whether he had a university degree. The matter sort of was settled, but it came back as part of the electoral, as part of the petition challenging his election, saying he was never qualified in the first place. How can he be elected if ab initio he was unqualified? Our court, by a majority with Chief Justice Maraga, who was with you dissenting, held that the court could not reopen any issue that had been dealt with at the pre-election phase. Judge Maraga and I disagreed, but the decision of the court stands that yes, you cannot reopen pre-election matters. So as far as our jurisprudence is concerned today, you cannot reopen matters determined at the pre-election level when you come to the election or post-election level. Justice Piri, the East African Court of Justice, and I sat there for 7 years, is mandated to interpret and apply the treaty for the establishment of the East African Community. Article 6D and 7.2 import rights, including rights under the African Charter on Human and People's Rights. So one of the rights is the right to be heard. So it's not as if the court per se sat on appeal of our decision. What the court said, it is merely acting within its mandate to interpret the treaty. And so it found that the court had violated the right to be heard by denying the Honorable Karua the right to have our case determined on the merits. Interestingly, by the way, last week we had, as the Supreme Court, a reference by the Attorney General of Kenya seeking an advisory opinion from the Supreme Court on how far the East African Court of Justice can go in determining matters which are connected to final decisions by apex courts in the East African region. So that matter is sub judice. We cannot discuss it, but it is there. So once we enter that decision, I think the connection between what the court in Arusha can do, what our courts can do, perhaps we'll find some answer. But for now, it is out there whether that court had the jurisdiction to determine a matter finalized by the apex court to a partner state. It is a matter that is out there, and that was the reasoning behind it. Thank you very much.
Justice Dinaola, there was, I don't know if you have responded to a comment that was made by the chair of the Zimbabwe Electoral Commission about people using the constitution and the law as a sword.
Yes, I did. It was my first comment, and I said that I agree with her, and that perhaps in this meeting, we can find mechanisms we don't allow mechanism for striking out petitions that are basically, you can see, we have no summary procedure in Kenya for striking out petitions that are obviously mischievous. Perhaps we can have a conversation here and say, do we have a mechanism within our rules, within our acts, where we can strike out mischievous petitions? There are many that we have seen in Kenya, for example, people using it to extort money from the respondent. Once they are paid the money, the petitions are withdrawn. So I know that they are misused. We need to find a mechanism, including summary dismissal procedures, if that is the case. So I did answer the question earlier. Thank you.
Thank you. Thank you very much. Chief Justice.
I have just two comments to make. The first one relates to the issue of the diaspora vote. This has been on for quite some time. The position in Zimbabwean law is that as we stand, it's a constitutional matter, in the sense that the Constitution itself makes provisions that exclude the diaspora vote from participating in an election. So you know, we have said we need to comply with the Constitution, and that is what has been done. The effects obviously may be not right, but for the courts, I think we are bound, and we have made our position clear. It's a constitutional matter, and there are avenues for rectifying that, perhaps in terms of the amendment to the Constitution. But at the moment, it's a matter of the Constitution making a provision which does exclude the vote. It's very specific on that it says for voters, they must be in physical attendance at polling station. That is what we say. Constitutionalism binds the judges. So you cannot interpret it otherwise, unfortunately. That is the position. It's not personal judges' views. We may not even share that kind of view, but that's nothing to do with the judges. The law is there, and especially when it's a constitution, we are bound by it, and it needs to be complied with. Then there are issues of, I think, approaches to the courts by people who may not have been the right people to vote, to participate in the electoral processes, because perhaps they have not been properly vetted by their parties, and so on. As I said, there are two levels of institutional participation in electoral processes. The first one, and both of them need to comply with the rule of law. And it's important for us to understand this. The first port of call is the electoral bodies that are responsible for managing the electoral processes. And the law is clear on how those bodies should act to ensure that the election is free, fair at the end. They can even go to the extent of finding measures where parties can come together, the code of conduct and so on. All that is meant for ensuring that the outcome is acceptable. And so that is consistent with the rule of law. And I think that, to be frank, most of the electoral bodies have done a good job. But not everybody will accept that. Some people say, whatever has happened, I have a second bite. I will go to the courts. That is the right of access. We as the judges, as the courts, cannot deny people the right of access, as long as they have put their right within the requirements of standing. If you find that you have the right to approach a constitutional court, for example, and you meet the requirements of who can lodge a presidential petition, and you are the candidate, you are aggrieved, and you show the grounds of your grievances and so on, we as a court, according to our constitution, are bound to hear and determine that application, for the simple reason that it's not an application for purposes of vindicating the interests of this particular litigant alone. It's a purpose of vindicating the whole process integrity. In other words, the vindication of the electoral integrity lies in these petitions. And well, even if we have to hear the merits of them, and solve those tensions, political tensions, you would rather do so. But the question is, having this kind of mechanism there, put in by the people, the majoritarian principles are alive. It's put by people, the judges are given that jurisdiction by the people constitutionally, and everybody is expected to accept that the judge has the integrity to make that decision, and that decision is correct. The only problem is those who approach the courts expect nothing else but one result. And when that result doesn't come, the judges and all the other people must be maligned. They are wrong, they are something else. They are against the law. That is where the problem is. I think I answered some of the question raised by the lady online. Thank you.
Right. Yeah, I think we have come to the, but before we declare this session closed, I just wanted to have a little footnote question for Justice Leonala. I know Chief Justice Malala has responded fully, I hope, to the question regarding the franchisation of the people in the diaspora. But I heard Justice Leonara talk about how he headed the progressive, a group that dealt with the progressive realization of the right to vote by people in the diaspora. I just wanted to solicit his comments on whether the situation in Kenya at the time he headed this particular group was similar to the situation obtaining in Zimbabwe, as we have heard it described by Chief Justice Malawi.
Oh, yes. Oh, yes. It is. And what I will do, I will send my presentation today and the judgment to Arnold Sunga, who will then circulate to members just to see how we addressed it in our situation. Because after my decision, then the Electoral Commission in 2017 was able to ensure that the voting by the diaspora is operationalized in a progressive manner, not that every Kenyan everywhere in the world would vote, but in a way that takes care of finances, logistics, and so on. So that I'll give the judgment, and then you could see whether it's a useful tool to progress the diaspora voting process in Zimbabwe.
Thank you very much. It's now 13 hours, and I think this is where this session ends. We declare ourselves no longer useful.
Thank you, Chief Justice Malila, Mumba Malila. So let's help me to give Chief Justice Malila a round of applause. And this takes us to the lunch break, and you've really helped us to catch up on time. And thank you a lot for that. We are going to take a break and try to be here as promptly as possible at 2 p.m. because again, there will be presenters online. And this time, this will be from another continent. So the question of time could be very critical for us to hear that presenter. So we take the break and then we meet at promptly 2 p.m. I'm going to ask the ushers from the JSC, really, when people are eating, just to remind them about time. Maybe from about 1:45, let's start reminding people that it's about 2 o'clock for people to come back here. Thank you very much indeed.
Not knowing which number to just one day, cancer, you're not supposed to take with that stuff. Oh, my carbohydrates, I do my bank out. You are actually feeding it. That is all sugar. Sugar. So much of the sugar at West. Because I did not. Order my pastor factory. Number.
Anang nya bos ada mau dinas. Ada mau ngabas. Ada agno ko bibi. Anang nya bes ta mau di nyumba. Agas ko. Siapa nyumba ka kita.
Mamuna yo ina kwela kula anapita anaima to tatu ile pasiki yako hapa osa za udamina kumimbia mamuna kumimbia swake ni yani sasa kwa hiyo kwa kule tatu jana mtagira wiki mzo ndo kale papa yo mai mamuna kwa kula sasa sasa nangu kundira kwa pera kwa yo
Kwanzovuta sanga ile mwakutana ngekufuna umimire amane kakubera panota kana baba yule mina yale mwalimu awili panofura na jambo gani ndio wakati ndio ndio
ndika abenda ndikasintoche ari je ndikasto dana pangana ni mamuno uzalo wa konkuja kuli kalo wa ni mamuno Pito kaya mena ujani kwa kila mtu wina kula kwa zote. Alafu kwa state ni mamuno pia na kia mamuno. Alafu awenda Gaston ni ya Gaston ni ari Gaston. Yeye ndio kupanga ni mamuna yo kalo wa ndio mimi kwa pia zote kwa sababu anaipo sipo. Uzina na bidii.
Colleagues, please mute. Please mute.
Kwa hiyo jana ndo wanamacho
Jack River and others, please mute. We can hear you. Thank you.
Hello.
Please mute. We can hear your conversation. Jack River,
Okay.
please. Thank you.
One, two, one. 1, 2, 1, 2, 1, 2, 2, 1, 2, 1, 2.
Good afternoon, honorable judges and distinguished guests. I'm very happy that you came back on time. When I looked at my watch, it seems to be saying 2 o'clock. I hope it's not mistaken. But others, thank you very much for coming. And without wasting too much time, let me invite Justice Maria Kawimbe, who is going to be the chair for the next session. Honorable Justice Kawimbe is a judge of the Constitutional Court of Zambia. She sits in the working group of the Africa Electoral Justice Network and has been really influential in the drafting of the founding statute and its adoption, as well as in the design of this program. So I'm very privileged to have been working with you, and I leave it to you to take over for this session, Judge.
Thank you for the introduction, Master of Ceremonies. Good afternoon, my lords, the Honorable Chief Justices, my lords and ladies of the Superior Courts. In the interest of time, I'll write on the protocols that have already been established. The theme of the second session is on protecting independence and impartiality of election judges. As we heard earlier on in the morning session from the Honorable Chief Justice of Zimbabwe, this is an issue that preoccupies most of the judiciaries and judges in particular. We have all at one point or the other been victims of very aggressive attacks, which have gone to attack our integrity as well as reputations. This is very worrying, and in more recent times, because the audience has become larger through the information and disinformation disorder fueled by social media. To stimulate the discussion of this very important but sensitive topic are three highly qualified speakers. I would like, first of all, to invite our keynote presenter to take the podium, Justice Zondi. Unfortunately, Justice Zondi's profile was not circulated in good time, so it is not in the program. But briefly to say that he is a judge of the Supreme Court of Appeals of South Africa. He is also the president of the Electoral Court of South Africa. He is a member of the Governing Council of the Global Network for Electoral Justice and sits on the African Electoral Justice Network. These two bodies, as you get to learn more about them, especially the African, specialize in developing EDR mechanisms and systems. So it gives me great pleasure to welcome Justice Zondi. You have 15 minutes.
Okay.
Okay. Right. Thank you very much, my sister, Justice Kawimbe, for a lovely introduction. Good afternoon, ladies and gentlemen. Protocol observed, but first of all, I would just like to greet my Chief Justices who are present here, judges of the Supreme Courts of various jurisdictions, and leaders of the electoral bodies. As I've just indicated, I will observe protocol. I just want to thank the organizers of this event for giving me an opportunity to share my thoughts with you on protecting independence and impartiality of election judges. The judiciary, as a third arm of the state, has a fundamental role to play in the electoral process. In all countries, judiciaries play an important role in stabilizing the balance of power within the government, and their performance can enhance public confidence in the integrity of government. The most fundamental values that underpin the Constitution and regulation of the judiciary are that judges must maintain their independence and impartiality. These values are enshrined in the Universal Declaration of Human Rights, that's Article 10, the International Covenant on Civil and Political Rights, that's Article 14, and the African Charter on Human Rights and People's Rights, that's Article 8, and in domestic, constitutional, and legal arrangements. It is these that form the guiding principles for international instruments, including the most recent Bologna-Milano Global Code of Judicial Ethics, 2015. Judicial independence in its form of institutional independence has been and still is invoked to resist the external regulation of judges, particularly by the political branches of the government. Now, where is the judiciary function located in the Constitution? In South Africa, the separation of power is constitutionally entrenched and enforced. Section 165 of the Constitution vests judiciary authority in the courts, and it guarantees their independence. The Constitution ordains that courts are subject only to the Constitution and the law, which they must apply impartially and without fear, favor, or prejudice. To ensure that the judiciary is independent and remains so independent, the Constitution imposes an obligation on organs of states through legislative and other measures to assist and protect the courts. An order or decision issued by the court binds all persons to whom an organ of states to which it applies. There are similar provisions in other jurisdictions, such as in Zimbabwe, Section 79B of the Constitution, Namibia, Article 78, Malawi, Section 103, Lesotho, Section 118, subsection 2, Uganda, Section 128, Zambia, Section 91, subsection 2, and Ghana, Section 127, just to name a few. So it's clear that the constitution of all this jurisdiction vests the judiciary function in courts. It is imperative to note, however, that judicial independence is not for the judge himself. It is for the citizens. It is there to ensure that their rights, when they are violated, there is an independent and impartial forum available where they can enforce their rights. Now, when it comes to adjudication of electoral dispute, recently we have witnessed the courts getting involved in all three phases of electoral process: the pre-election, the election itself, and the post-election phase, to resolve the electoral dispute, be it allegation of serious violation of electoral laws, leadership disputes, registration of political parties, or where there are allegations of electoral fraud, such as registration of voters in the wards where they are not resident. The judiciary has played a very crucial role to ensure that there is a peaceful transfer of power following elections. It is therefore important that the members of election petition tribunals and electoral courts are independent and impartial. In other words, in adjudicating an election-related dispute, the judges of these institutions must always bear in mind that an objective of the electoral process is to produce free and fair elections. The free and fair election will be one where an eligible voter is afforded an opportunity to participate in the process. The process must be managed by an independent electoral body, and that process must be transparent. The process must be such that it affords an aggrieved candidate an opportunity to challenge the result before an independent courts of tribunal. One should not find a situation that there is a provision in the Constitution which provides that the position of the president cannot be challenged once he's elected, because that will be contrary to the fair electoral process. An aggrieved candidate must be able to challenge the results. Now, at the same time, judges are subjected to attacks against their integrity during elections. We have seen that in a number of jurisdictions. Allegations of rampant corruption against tribunal and appeal panelists are often made in the media. And unfortunately, we as judges do not have control over the media or social media. So traditionally, we talk through our judgments. So when it comes to media issues or social media issues, we are vulnerable because we've got no one to defend us. And I think that is where we should come up with a process or mechanism that is going to ensure that the judges who participate in the election-related dispute are protected. That is the challenge for this conference. Some of these attacks, however, can be avoided by making sure that the manner in which judges manage cases is beyond reproach, and that they are not dismissive in the adjudication of the petitions. They should not conduct themselves in a manner that will raise perception of bias. Judicial independence goes hand in hand with accountability, transparency, efficiency, and representativeness. The focus on the values of accountability and transparency, for instance, is recognized in the preamble to the Bangalore Principle of Judicial Conduct of 2002, which states that the principles presuppose that judges are accountable for their conduct to appropriate institutions. This shift reflects an increasing concern with the significance of the power wielded by the judiciary and the acceptance that those that are given this responsibility are human and fallible. This has also been accompanied by a more general emphasis and expectation of accountability and greater transparency for all of those who exercise public power. Representativeness is now a common judicial goal, underpinned by the principle of equality and acceptance that judicial legitimacy will rest to some extent on the extent to which it represents the community in which it operates. These values are instrumental and exist to foster the objective of maintaining and enhancing public confidence in the institution of the judiciary. Efficiency in the judiciary is closely associated with access to justice, with judiciaries in developing an established system alike often criticized for delays in dispensing justice. We should make sure that we try to deliver our judgment as soon as possible, because if we delay judgment, handing down judgment, that might give rise to a perception that there is something amiss. So we should make sure that we render our judgment as soon as possible. More especially in electoral cases are by nature inherently urgent, and they must for this reason be dealt with expeditiously. Litigations arising from elections should not be allowed to drag on for years after the presumed winners have been sworn in. All election cases must be decided far ahead of inauguration ceremonies. The cornerstone of public confidence recurs across international and judicial and domestic judicial regulation. It is asserted time and again that it is this concept of public confidence that allows judges to fulfill their fundamental role of resolving disputes that arise in both private and public law spheres. For instance, the Bologna-Milano Global Code of Judicial Ethics states, I quote, "Public confidence in the judicial system and in the moral authority and integrity of the judiciary is of the utmost importance in a modern democratic society. And it is essential that judges individually and collectively respect and honor judicial office as a public trust and strive to enhance and maintain confidence in the judicial system," close quote. If members of the public have confidence in the judiciary, they will criticize any tendency by the executive and politicians to interfere with its work. Baseless attacks on the judiciary should be discouraged, and it is for the government of the day to publicly denounce any such attacks, and failure to do so may be perceived as a failure to promote judicial independence. In conclusion, ladies and gentlemen, it is of utmost importance that the independence and impartiality of the judges, and in particular, the election judges, must be protected and promoted. However, that does not mean that a judge who violates the law or rule which regulates ethical behavior should not be called upon to account, as such conduct may have a potential to bring the judiciary into disrepute. All judiciaries should have in place effective mechanisms that regulate the conduct of the judges so as to avoid any conduct that may pose a threat to the independence and impartiality of the judges. I thank you, ladies and gentlemen.
We can do better than that. Thank you very much, Justice Wandi, for your very insightful presentation. We shall now transition to the next presenter, who is Commissioner Remy Ngoy Lumbu, the chairperson of the African Commission on Human and People's Rights. He is also the Special Rapporteur on Human Rights Defenders and focal point on reprisals and on independence of judiciary. The Commissioner will make a presentation on the AU mechanism on the protection of independence of judges and lawyers in the context of electoral justice. You have the floor.
Good afternoon. Je pense que je vais m'exprimer en français, que vous allez avoir besoin de vos casques pour que nous puissions nous comprendre. J'ai une grâce particulière pour avoir pris part au dialogue judiciaire que la Cour africaine des droits de l'homme et des peuples avait organisé au mois de novembre, dernière semaine du mois de novembre 2023 à Alger, sur un thème très important, la promotion des droits de l'homme en Afrique, les défis et les opportunités pour la transposition de la jurisprudence régionale et internationale en matière de droits de l'homme au niveau de juridiction nationale. On parle bien de la transposition de la jurisprudence régionale et internationale en matière de droits de l'homme au niveau des juridictions nationales, ce qui signifie, d'abord, ce forum-là, c'est un dialogue judiciaire que la Cour africaine, qui est un des principaux organes judiciaires de l'Union africaine en matière de droits de l'homme, organise sur le continent, et la Commission africaine prend part à ce dialogue aussi. Lorsqu'on parle de transposition, ça signifie qu'il existe aussi une autre forme de dialogue entre les institutions internationales, continentales et internationales, internationales au sens des Nations Unies, et les juridictions nationales, dont les chiefs justice, que je salue tous ici, à qui je présente mes respects, ont, n'est-ce pas, la charge d'animer et de conduire ces institutions nationales aux meilleures destinées de notre continent. Chez nous, c'est-à-dire à l'Union africaine, et précisément à la Commission africaine, c'est un discours que j'aime bien, c'est une phrase que j'aime bien prononcer, c'est que l'Afrique que nous voulons n'est pas encore celle que nous avons actuellement. Sinon, on ne serait pas en train de se retrouver ici cet après-midi. L'Afrique que nous voulons n'est pas celle que nous avons, mais celle que nous pouvons avoir demain dépend en grande partie de ce que nous faisons aujourd'hui, en ce compris ce que nous faisons dans cette salle. Et cet après-midi, j'ai été présenté, professeur Remy Ngoy Lumbu, de l'Université de Kinshasa en République démocratique du Congo. Je suis à ma 3e année comme président de la Commission africaine des droits de l'homme et des peuples, rapporteur spécial sur les défenseurs des droits de l'homme, et point focal sur les représailles. Et depuis la 77e session ordinaire que nous avons organisée en Tanzanie, je suis également le focal point, le point focal sur l'indépendance judiciaire en Afrique, un thème qui nous porte à cœur au niveau de la Commission africaine des droits de l'homme et des peuples. Je voudrais remercier les organisateurs de cette importante activité, de ce symposium, qui implique 2 États, si mes données sont bonnes. Il s'agit du Zimbabwe et de l'Afrique du Sud, qui sont 2 grandes nations exemplaires, révolutionnaires, qui ont mené toutes les batailles en Afrique, en ce compris les batailles judiciaires de très haut niveau et de très grande importance. Ils ont beaucoup de choses à apprendre aux autres pays. Ils ont beaucoup de choses à apprendre même au continent. Je voudrais également remercier les partenaires qui ont fait que nous puissions nous retrouver cet après-midi. Pan-African Defenders, Africa Judge, un Jurist Forum, la CACJE, le Forum des présidents des Chief Justice d'Afrique australe et d'Afrique de l'Est, la SAGEI, l'Institut pour l'éducation judiciaire en Afrique australe. De manière individuelle, personnelle, je voudrais exprimer ma gratitude au Chief Justice du Zimbabwe, l'honorable Luke Malaba, et à Monsieur le juge Mba, un juge à la retraite selon les informations qui m'ont déjà été données, mais il reste juge parce que ces réflexions des juges sont toujours fraîches. Pour avoir signé l'invitation qui m'a permis de venir ici, malgré un emploi du temps quand même un peu chargé. Vous savez que le comité de représentants permanents est en train de se réunir pour l'instant à Addis Abeba. Je n'ai pas hésité de venir parce que depuis que ce mécanisme a été créé au niveau de la Commission africaine, il s'agit d'une première activité à laquelle je participe en présentiel en tant que point focal sur l'indépendance judiciaire sur notre continent. Selon le cahier des charges, il m'a été demandé de prendre part à cette deuxième session. Je crois que le contrat est rempli parce que je suis là quand même. Je suis arrivé il y a à peine 1 heure. J'ai tenu à venir directement dans cette salle pour écouter déjà ce qui se disait à la première session et créer un lien avec ce que nous allons faire ici à la seconde session. Et cette seconde session porte sur la protection de l'indépendance et de l'impartialité des juges électoraux. L'indépendance et l'impartialité des juges électoraux. Je voudrais dire des juges qui sont impliqués dans les litiges ou dans les contentieux électoraux. Cette mission, contrairement à ce qu'on pense, n'est pas simple. N'est pas aussi simple qu'on peut l'imaginer, car les élections en Afrique, et c'est le dit pour les 55 pays, au moins pour les pays qui organisent les élections, pas pour les royaumes, pour les pays qui organisent les élections sont des sources de tension permanentes. Les élections sont des sources de tension permanentes. Je parle en connaissance de cause, je connais le nombre de cas, même si certains n'aboutissent pas, pour lesquels la Commission africaine des droits de l'homme et des peuples est saisie. À chaque élection, quasiment, nous sommes saisis du mal jugé, des juridictions supérieures. Dans tous les pays sur le continent, il n'y a pas d'exception à cet égard. Si certaines affaires n'arrivent pas à aboutir, certaines communications n'arrivent pas à générer une communication sur le fond, ça ne signifie pas que le contentieux n'existe pas. Le contentieux existe toujours. Une première interpellation, c'est de dire au chief justice, de dire le droit, rien que le droit à l'état pur, non le droit dilué, non le droit influencé par les considérations politiques, parce qu'après la lecture des litiges, après la solution qu'ils donnent, la chose n'est pas finie. Il va de l'honneur de leur pays déterminer le contentieux au niveau national et de ne pas voir ces contentieux aller au niveau international. Pour ceux qui suivent l'actualité internationale, ils savent même que, par exemple, pour la Cour africaine, certains États se sont même retirés du protocole créant la Cour parce que la Cour s'est prononcée sur des contentieux électoraux. Implicitement, dans la charte africaine, nous ne trouverons pas le droit à des élections, bien évidemment, comme cela figure dans le pacte international relatif aux droits civils et politiques. L'article 13.1 de la charte africaine des droits de l'homme et du peuple nous parle du droit de participer librement à la direction des affaires publiques de son pays, soit directement, soit indirectement. Directement, c'est par les nominations, indirectement, c'est vis-à-vis, enfin, en passant par les représentants qui sont élus. Je voudrais, à cet égard, comme je le disais dans mon introduction, que le droit de prendre part à la direction des affaires publiques de son pays, un droit qui revient à tout citoyen, est menacé en Afrique. Je vois à mon niveau personnel 3 types de menaces. Le bourrage des urnes, ce n'est pas quelque chose d'irréel, c'est à travers les réseaux sociaux aujourd'hui, on sait voir partout où se passent les élections, comment les gens se comportent dans les bureaux de vote. Il y a bourrage des urnes. Est-ce que les gens qui bourrent les urnes physiquement sont-ils sanctionnés par les juges comme il se doit? Je vous laisse répondre à cette question. Ça, c'est la première forme d'échec de l'Afrique à ce sujet. C'est tellement flagrant et honteux. À la faveur de nouvelles technologies d'information et de communication, nous savons tous aujourd'hui qu'un bureau de vote se limite aujourd'hui à une machine. Vous avez vu les récentes élections qui ont été organisées en Afrique. Il y a même des hommes politiques qui se permettent aujourd'hui d'avoir des dispositifs électroniques de vote dans leur propre maison, de voter toute la nuit et d'arriver le matin avec des résultats. Une autre forme de contentieux est en train de naître en Afrique pour la première fois. On voit des individus avec des mallettes de vote en train de voter pour eux-mêmes ou pour des gens pour qui ils ont été mandatés. Si cela n'est pas le cas, le bourrage des urnes physiques ou bien la mise à disposition des dispositifs électroniques de vote, on a une troisième forme. C'est laquelle? C'est la manipulation même des élections par les commissions électorales indépendantes. Et chaque fois qu'on me parle de commissions électorales indépendantes, je rigole un peu parce que quand on voit la manière dont ils se comportent vis-à-vis de l'exécutif, il y a lieu de penser que cette indépendance n'est que de façade. Donc, des élections sont de plus en plus contestées en Afrique, ça génère des contentieux et il n'y a pour arbitre que les magistrats. Face au Léviathan, le pouvoir public, et face à la population, le seul rempart qui reste, il n'y a que le magistrat. Ça sert à quoi alors d'aller aux élections si on n'a pas de magistrats et des juges indépendants? C'est eux les arbitres, c'est eux qui peuvent nous permettre de départager demain les candidats, les populations avec le pouvoir. C'est eux qui peuvent nous permettre demain de départager le pouvoir et l'opposition. C'est très important. Sinon, toute la démocratie n'a plus sa raison d'être parce que la démocratie, c'est le pouvoir du peuple qui doit se choisir les dirigeants qu'il veut. Mais si déjà dans la démocratie, les dés sont pipés à l'avance, les capacités de fraude sont assez importantes sur notre continent, si déjà cela est pipé à l'avance, je me demande comment les gens vont s'en sortir demain et quel type de démocratie nous sommes en train de mettre en place. Quel type de démocratie nous sommes en train de mettre en place. Il ne reste que les droits de l'homme comme recours, comme rempart pour les populations. Et le droit électoral est un droit de l'homme, comme je l'ai dit, article 13.1 de la charte, point 1 de la charte. Le contentieux électoral, comme vous le savez, il est transversal. Il prend en otage tout le système judiciaire parce qu'il commence au niveau le plus bas pour les élections les plus basses, il monte jusqu'au niveau le plus haut pour les élections de niveau assez élevé. Il faut faire très attention parce que la crédibilité des systèmes judiciaires est lui-même sujet à caution. Il doit être encadré, le contentieux électoral, très bien encadré. S'il n'est pas encadré, nous courons tous vers l'échec de la démocratie. C'est pour ça que dans mon introduction, j'ai dit, l'Afrique que nous voulons n'est pas encore celle que nous avons. Moi, je le dis, je suis un expert indépendant au niveau des Nations Unies, au niveau plutôt de l'Union africaine. J'ai cette possibilité de le dire parce que je ne suis pas un agent du gouvernement. C'est pour ça que mon discours est tout à fait différent et il doit être tout à fait différent des autres discours des chefs de justice ou des procureurs généraux de la République ou des ministres de la justice. La commission n'est pas restée insensible. Je salue dans la salle, je ne sais pas si ma myopie me permettra de le voir. J'ai vu qu'un ancien vice-président de la commission africaine, Dr Mumba Malila, qui était ici le matin, ils ont commencé avant moi, parce que je ne suis arrivé à la commission que vers les années 2017. Avant moi, il y a eu des gens qui ont travaillé. Très bien travaillé. Parce que conscients de cette situation, ils ont commencé déjà à proposer les normes pour encadrer l'indépendance judiciaire, pour encadrer le procès équitable. Et je vous rappelle par exemple, c'est depuis les années 92, 92 pour ceux qui parlent le français de Belgique, que la Commission africaine a pris conscience de l'importance d'une justice indépendante, en ce compris la justice électorale, d'une impartialité des juges. C'est depuis les années 92 que la Commission africaine a commencé à penser à cette question. Quand on voit déjà que la Commission a commencé à travailler depuis les années 87 et que c'est seulement en 92 qu'elle le fait, elle a été très précoce, très rapide en cette matière. Je voudrais donc vous dire ici que nous avons deux temps forts au niveau de la Commission. Dans un premier temps, moi je pense que la Commission africaine des droits de l'homme et du peuple a aligné des normes. Elle a commencé par générer des normes et dans un second temps, elle a mis en place, comme je vous le dis, récemment lors de la 77e session que nous avons eue fin décembre au mois en Tanzanie, un mécanisme pour s'occuper de cette question. La première résolution, c'était la résolution numéro 4, adoptée à la 11e session en 82, la résolution sur la procédure relative aux droits, au recours et au procès équitable. Droit au recours et au procès équitable. Il faut permettre à tous ceux dont les droits de l'homme sont violés puissent avoir un recours, un droit de recours, d'aller saisir le juge. J'ai dit c'est un contentieux transversal. Il commence au niveau le plus bas des juridictions, il monte jusqu'au niveau le plus haut. Les individus qui se sont présentés aux élections, les individus qui ont des raisons valables de penser que les élections n'ont pas été justes, ils doivent avoir un droit de recours. Est-ce que dans tous les pays d'Afrique, on organise des droits de recours pour ces gens? Je ne pense pas ce matin. C'est pour ça que je suis content d'avoir été ici. J'apprends que dans quelques pays, par exemple, la diaspora ne vote pas. Est-ce que ces gens ont un recours? Même si cela est mis dans la Constitution. Nous savons qu'en matière de droits de l'homme, on ne peut pas limiter un droit de l'homme de manière à en vider même le contenu. Lorsqu'on dit aux gens, vous êtes de la diaspora, vous ne pouvez pas voter, quelque part pour nous, dans les standards africains, ça devient un tout petit peu problématique. Une seconde résolution, la résolution 21, adoptée à la 19e session de la Commission en 1986. Cette résolution parle aussi du renforcement du respect, il parle du respect et du renforcement de l'indépendance de la magistrature. Renforcement du respect de l'indépendance de la magistrature. La magistrature est-elle vraiment indépendante? Je suis aussi magistrat. Je me suis toujours posé la question si la magistrature était vraiment indépendante du pouvoir public, enfin, du gouvernement. Je ne le crois pas. C'est une vue de l'esprit. Si nous réveillons Montesquieu, qui a fait les théories de séparation de pouvoir pour que le pouvoir se contrebalance les uns et les autres, on voit que l'exécutif a toujours une mainmise. Et je rappelle souvent aux magistrats, ils n'aiment pas ça. Parce que je ne suis pas encore haut magistrat en haute cour. Peut-être demain, je le serai. Quand je suis avec les magistrats des hautes juridictions de chez nous, je leur dis, vous avez le devoir d'ingratitude. Vous n'avez pas le devoir de remerciement lorsqu'on vous a nommé, lorsqu'on vous a placé à un niveau. Une fois que vous êtes nommé, restez indépendant, vous avez un devoir d'ingratitude. La Commission insiste sur l'indépendance de la magistrature. Troisième résolution avant la dernière, la résolution 41. C'est une résolution que nous avions adoptée à la 26e session de la Commission africaine des droits de l'homme et du peuple en 99. C'est la résolution sur le droit à un procès équitable et à l'assistance judiciaire en Afrique. La résolution sur le droit à un procès équitable. Aller dans un contentieux électoral de n'importe quel niveau, où vous êtes en opposition avec un politicien influent dans son pays, parce qu'on a mal réparti les sièges, parce que vous pensez que les voix qui étaient les vôtres ont été attribuées à ce politicien qui a pignon sur rue, vous allez sentir dans votre chair ce qu'on appelle le procès équitable. Parce que plus que probablement, il va gagner les élections à votre détriment. Il vous dira même à l'avance, allons-y, vous verrez, je vous gagnerai, même si vous pensez que j'ai triché aux élections. Enfin, nous avons adopté, en dehors des résolutions, nous avons même proposé à l'Afrique. Mon collègue des Nations Unies a parlé tout à l'heure du système des Nations Unies. L'Afrique n'est pas en reste. nous avons les directives et les principes sur le droit à un procès équitable. On a réuni tous les grands principes maintenant sur le droit à un procès équitable et à l'assistance judiciaire à travers des lignes directrices que nous avons proposées à l'Afrique. Vous pouvez vous y référer en tant que juge, mais les parlementaires aussi peuvent s'y référer en tant que créateurs de normes pour qu'ils puissent créer des lois qui respectent les standards africains. Tout à l'heure, on parlait dans la session 1 de ce matin, il y a une dame qui posait la question de savoir s'il y a des standards continentaux face à la question qu'elle posait, parce qu'elle disait, est-ce qu'il existe un mécanisme qu'on peut utiliser lorsque dans le processus électoral national, des droits sont violés? Est-ce qu'il existe les standards africains? Les standards africains existent. Je viens de vous donner 3 résolutions et je viens de vous donner les lignes directrices. C'est ce que vous appelez, vous les anglophones, de la soft law. Ce sont des principes auxquels on peut se référer pour prendre position dans les litiges qui sont les vôtres. Ce sont les principes auxquels les parlementaires peuvent se référer pour améliorer la qualité des lois dans nos pays respectifs. Deuxième temps fort, je vais terminer par là parce que je pense que j'ai dépassé le temps. Il faut m'arrêter, madame, sinon je pourrais parler pour 1 heure. Nous avons créé maintenant un cadre de monitoring de la question de l'indépendance judiciaire et de l'impartialité des juges. L'Union africaine vient de créer un mécanisme, un point focal au niveau de la Commission africaine, votre humble serviteur. Depuis la 77e session en 2023, je vous ai parlé de cette session ordinaire que nous avions tenue à Arusha, en Tanzanie, avec des missions précises. Première mission, c'est rechercher le facteur qui nuisent à l'indépendance des juges. Quels sont les facteurs qui nuisent à l'indépendance des juges, surtout dans des contentieux aussi politiques et problématiques comme les contentieux électoraux? Interroger les pratiques nationales des États, les pratiques administratives, les pratiques législatives qui limitent l'indépendance des juges par rapport à cette question. Faire rapport, informer régulièrement la Commission africaine, c'est ce que je dois faire pour qu'elle puisse prendre des actions et aider les États à aller de l'avant dans ce domaine du contentieux électoral. C'est la mission que j'ai eue. Pour l'instant, je suis en train de préparer un rapport initial sur cette question-là, mais chaque année, la Commission, jusqu'à ce que je terminerai mon mandat à la Commission, chaque année, la Commission demande de présenter un rapport annuel par rapport à cette question de l'indépendance judiciaire. Quel est le mot de la fin que je pourrais dire? Soyons conscients d'une chose. Les juges sont les défenseurs des droits de l'homme. Les juges sont les premiers défenseurs des droits de l'homme. Parce que le système international ne peut fonctionner que si les juges font d'abord leur travail. Nous attendons beaucoup des juges, quel que soit leur niveau, quelle que soit leur responsabilité, pour que dans ce contentieux spécifique, dans ce contentieux spécialisé des élections, qui est un contentieux de la démocratie, que votre rôle soit un rôle qui impacte le développement de l'Afrique, que vous nous puissiez dire le droit, rien que le droit, quand bien même nous savons et nous en sommes conscients, les juges en parlent, vous subissez souvent les pressions des pouvoirs publics. Je rappelle, vous avez le devoir d'ingratitude vis-à-vis de ceux qui vous ont nommé. Il y a une vie après la fonction des juges, mais un juge qui dit bien le droit, surtout le droit du contentieux électoral, gardera sa conscience tranquille tout le long de sa vie. Voilà le peu d'éléments que je voulais partager avec vous. J'allais m'étendre sur les lignes directrices, mais le temps fait défaut, les lignes directrices de la Commission sur l'indépendance de la magistrature et le procès équitable. Mais peut-être dans les débats, lorsque les questions viendront, je pourrai répondre à l'une ou l'autre question. Mesdames et messieurs les chiefs de justice, distingués participants, tel est le contenu du message que je voulais vous apporter et je vous remercie pour votre attention.
It gives me great pleasure to welcome the third panelist, Ms. Margaret Southwhite, who is joining us virtually. She is the UN Special Rapporteur on Independence of Judges and Lawyers. I welcome you.
Thank you very much. Good afternoon and bon après-midi. Your honors, dear distinguished judges, I'd like to start by expressing my gratitude and congratulations to the Africa Electoral Justice Network for your work organizing this event and bringing attention to the important role of the judiciary especially an honor to speak with many for the honor, most especially for the invitation from Honor Mr. Justice Malaba, Chief Justice of Zimbabwe, to be here with you. I also want to thank Dr. Arnold Sunga and Dr. Justice Madvid Zenge for their collaboration. And I was very pleased to have had the opportunity to hear the remarks of Commissioner Professor Remy Ngoy Lumbu, with whom I hope to work closely and whom I will be using le devoir d'ingratitude as an excellent concept for the work in this area. There's nowhere I would rather be than Victoria Falls. However, I'm sitting in New York this morning and pleased to be here. I'd like to start with a brief introduction to the UN Special Procedure System and how my mandate may be able to support your important work as independent judges. Special rapporteurs, commonly known as mandate holders, are independent who are appointed by the UN Human Rights Council to serve in our individual capacity. We are appointed by the 47 country members of the UN Human Rights Council to report on human rights issues affecting specific countries or on particular human rights themes which have a global impact. Currently, the thematic mandates cover matters as diverse as torture, the right to housing, business and human rights, climate change, and many more. This system, known as special procedures, has expanded rapidly since the creation of the first mandate in 1980. There are currently 14 country-specific mandates, more than 40 thematic mandates, and 6 working groups. Mandate holders have 3 main functions. First, we address complaints of human rights violations by engaging in correspondence with the alleged violator state or non-state actor through a process that results in a public statement called communications. We also conduct 2 official country visits annually, publicly reporting on issues within our mandate and making recommendations to governments to address human rights deficiencies. Finally, mandate holders produce 2 thematic mandate reports per year. These are submitted first to the Human Rights Council and then to the General Assembly. We offer recommendations to states and other stakeholders in these reports concerning the rights under our mandate. So what is the theory of change governing the work of special procedures mandate holders? Of course, this depends on the mandate and the particular human rights problem in question, but generally speaking, special rapporteurs possess soft power. Our work impacts human rights by raising public awareness, spotlighting calls for governments to improve their practices, hands information and norms to the public, and document rights situations for further monitoring. We engage in dialogue with governments to offer technical advice and contribute to the development of international standards. Our thematic reports provide influential interpretations and are referenced by judgments in courts and academics. In this respect, I hope to offer my support to you as eminent judges. And finally, it is our job to speak out when things are going wrong. And so this means often making ourselves unpopular with governments who might be violating rights, but speaking the truth to power. As it relates to my mandate, I assumed the role as Special Rapporteur on the independence of judges and lawyers in November 2022 for an initial 3-year term. The scope of my mandate, as set out in the original 1994 resolution, is to identify, record, and respond to attacks on the independence of the judiciary, lawyers, and court officials, and to report on progress achieved in protecting and enhancing that independence. I'm also tasked with identifying and making concrete recommendations about ways of improving the judicial system. And this is a global mandate, meaning I can work on issues in any country around the world. And so as you can imagine, I very much rely on the work of experts and on the work of judges in bringing my attention to issues that are cropping up. How does this work relate to the rights enshrined in the International Bill of Rights, and specifically the International Covenant on Civil and Political Rights? Article 14 of the covenant guarantees the right to a fair and public hearing, and I'm sure you all know this very well, by an independent and impartial tribunal established by law. To give effect to this right, the independence and impartiality of the tribunal's decision makers must be secured by law, and it also must be respected in practice. In General Comment 32, the Human Rights Committee clarified that the requirement of competence, independence, and impartiality of a tribunal is an absolute right, not subject to any exemption, and that states must take specific measures to guarantee the independence of the judiciary. Article 14 requires that a tribunal must be both independent and impartial, and on the distinction between those requirements. Independence refers to the procedure and qualifications of appointing judges, the guarantees relating to security of tenure, conditions governing promotion, transfer, suspension, and cessation of functions. Independence also concerns the actual independence of the judiciary from political interference by executive and legislative branches of government. Impartiality requires judges to require their judgments are not influenced by personal bias or prejudice, and that they do not improperly promote the interests of one party to the detriment of another. So tribunals must not only avoid partiality, but they also must avoid the appearance of partiality. So the ICCPR sets out specific requirements relating to the protection of judicial independence and impartiality. But the reasons for guaranteeing the independence of judges extend far beyond the limited formulations in Article 14. Indeed, the principle of judicial independence is the bedrock foundation on which the other rights enshrined in human rights law rest. That's the case for two reasons. First, a strong, impartial, and independent legal system plays a central role in guaranteeing individual rights. That is true of all protected rights, civil, political, social, economic, not just the ones enumerated in the ICCPR. Judicial enforcement of rights is important for so many reasons, because enforcement can lead to reparations for those impacted by rights violations, because enforcement helps to articulate and develop the jurisprudence of rights, and because enforcement moves rights claims from the theoretical to the concrete, demonstrating the power of individual, community, and personal rights against the sometimes abusive might of states, companies, and other powerful actors. Judges who are not independent cannot uphold rights claims without fear or favor. A judge who fears dismissal or harassment by the government will struggle to find that the state, for example, committed acts of torture, or that the arrest and harassment of those who protest against the government is a violation of the right of peaceful assembly. Judges who are partial cannot constitute a bulwark against discrimination. Independence and impartiality are requirements of a good quality justice system, which is an essential component of access to justice, which is in turn essential for realizing protected rights. But the importance of these principles goes beyond the enforcement of individual rights, which brings me to my second reason for stressing the independence of judges as vital to the realization of rights. That is that the independent and impartial legal system is a key pillar of the democratic system of government. The judiciary is one of the key institutions that guards the health of a democracy. Independent judges guarantee that the same laws are applied to everyone, and they ensure that nobody is above the law, whatever their level of wealth, power, or political status. They ensure that society is governed on the basis of predictable laws rather than the will of an autocrat. An autocratic system of government poses a potential threat to all of the rights, enshrined under human rights law. If there's no effective check on the power of the state, governments are free to subject their opponents to surveillance, harassment, arbitrary detention, and even torture, to impose curfews and restrictions on citizens' movement, to discriminate against disfavored groups, and to restrict freedom of religion, belief, and expression. In short, they're free to systematically violate any and all of the rights protected by human rights law. This makes it all more alarming that we're living in an age of rising authoritarianism and democratic backsliding, in which the rule of law is coming increasingly under threat. Assaults on the rule of law play a central role in today's democratic recession. Currently, threats to democracies often don't take the form of military coups or drastic constitutional reforms. Instead, we're seeing democratically elected leaders assuming power and deliberately and gradually undermining basic guarantees, including judicial independence, electoral integrity, and freedom of expression. The role of the judiciary in checking executive power makes judicial systems ripe targets in declining countries. And evidence around the globe points to a common thread. When there's a threat to democracy, judicial independence is key. A strong and impartial independent legal system plays a central role in guaranteeing all individual rights, including the key right to participate in public affairs, voting rights, and the right of equal access to public services enshrined in Article 25 of the International Covenant on Civil and Political Rights. General Comment 25 of the Human Rights Committee specifies that whatever form of constitution or government exists in a country, the covenant requires states to adopt such legislative or other measures as may be necessary to ensure that citizens have an effective opportunity to enjoy the rights that Article 25 protects. The general comment also adds that an independent electoral authority should be established to supervise the electoral process and to ensure that elections are conducted fairly, impartially, and in accordance with established law, which are compatible with the covenant. There should be an independent scrutiny of the voting and counting process and access to judicial review or other equivalent process so that electors have confidence in the security of the ballot and the counting of the votes. This means that in many countries, the judicial role in ensuring elections are carried out in a free and fair manner is essential. As democracy erodes, these rights are threatened by regimes that attempt to manipulate electoral rules to their advantage by imposing restrictions on voting rights and candidacy and increasing the likelihood of partisan interference during vote counting and certification. Other attacks on democratic electoral processes include the adoption of emergency measures that suspend constitutional protections or the arbitrary arrest of political opponents. Across the globe, Supreme Courts have aggressively fought back against authoritarian attacks on democracy. In June 2023, the Mexican Supreme Court denied the government's attempt to defund the independent electoral branch. Similarly, the Brazilian Supreme Court has investigated potential coup d'etat planned by Jair Bolsonaro's supporters, and the Superior Electoral Court took proactive measures, such as issuing press releases attesting to the safety of the electoral process. The Electoral Court went so far as to disqualify Bolsonaro from running for office in the future. Those are just two examples from Latin America, and I will refrain from commenting on my home country of the United States as we are in the middle of this kind of electoral debate right now. Given the centrality of independent judges to the realization of these rights, what threats to judicial independence should we be especially alert to? There are two particular ways that I'll touch on that are very common across the world and that I have seen personally in communications and complaints that are coming to my mandate. First, autocratic governments or declining democracies erode the separation of powers in an attempt to make judges of one mind with the government so they won't restrict or challenge its authority. And this is sometimes done by introducing new limits on the power of courts to review the legality of executive or legislative actions, or by improperly assuming control over disciplining judges, either directly or indirectly by influencing the composition and conduct of judicial councils. Judges may be removed arbitrarily for no apparent cause or in order to further specific political goals. In support of the decision to remove them, judges may be subject to vague accusations substantiated by minimal evidence. Reasons cited in favor of removal may include allegations that judges are politically motivated or that they are biased in favor of certain parties that appear before them. While it's necessary to guard against impartiality and the politicization of judges in order to ensure judicial independence, this is also a convenient excuse that appeals to populist narratives of distrust of the system and the need to oust so-called elite judges. Additionally, judicial independence may be undermined through changes presented as reforms to the nature or composition of courts. This sometimes includes taking increased control of judicial appointments and promotion. Politicians may seek to alter the rules or processes around selection in ways that diminish the focus on professional qualities and increase the importance of political affiliation. Sometimes political powers seek to alter judicial term lengths by reducing the term for which judges serve or by introducing or changing mandatory ages of retirement. Of course, reform is always important. The question in assessing any so-called reform is to look and see whether it, in practice, will erode the independence of the judiciary and hand political powers more control over the courts. Finally, political leaders may discredit, harass, and attack judges so that they fear to make decisions that will attract the ire of politicians. And when they do, so that they may not be trusted or supported by the public at large. In General Comment 32, the Human Rights Committee made clear that states must protect judges against intimidation. But in countries around the world, we see that judges are subject to threats and attacks, both in person and especially online. Many states fail to provide adequate protection for judges or accountability for the perpetrators of such attacks. Even worse, we see many instances in which governments themselves are the very source of the harassment. States can also undermine judges' credibility and status in society by making public statements that denigrate judges, that denigrate legal professionals more broadly. Such criticisms may have limited or no basis in fact, or be based on reckless misinterpretation of judicial decisions. Abuse of this kind often decries judges as out of touch or failing to respond to the will of the people. Of course, judges are not perfect, and it's vital that states do not punish or censor legitimate criticism of public officials, including judges and judicial decisions. But judges should benefit from the general protections afforded to all protections not to be harassed, defamed, or otherwise attacked. These attacks subvert the status of judges in society so that citizens will be less likely to protest at steps that reduce their independence. These are not the only interests that can impact the independence of the judiciary. Individuals and businesses with significant economic power and status can also seek to influence judges to obtain more favorable outcomes. If these are some of the myriad problems facing judicial independence, what are some of the solutions? The first is to remain vigilant to threats and respond to them, to ensure that judicial reforms are appropriately questioned, debated, and challenged, and that individual judges receive support when they fall victim to unwarranted attacks. In the context of elections, identifying early indicators of a threat to democracy is crucial to mitigating its impact. There are early signs that may manifest through restrictions on voting rights or the targeting of electoral oversight entities. In my role as special rapporteur, I'm committed to ensuring that concerns about attacks on individual judges are brought to the attention of governments and the international community, as well as highlighting patterns and identifying and disseminating best practices for combating such threats while upholding human rights. There are many positive steps to be taken, and I know that you will be discussing and debating the best steps that work for you. I'd like to finish by saying that I very much support your important and independent role, and my mandate stands ready to speak out when your independence is attacked and to come to your side when you need international support. I thank you very much for the time, and I wish you the best with the rest of your meeting. Thank you very much.
I would like to thank Ms. Satterwhite for her enlightening presentation, but also to thank Commissioner Ngoy for his thought-provoking presentation. On a lighter note, he presented it with so much passion and was waiting for those punchlines during the translation, but they did not come through. So if we did not share your enthusiasm, Commissioner Ngoy, it's just because it was not coming through during the interpretation. So I now open the floor to discussions. Considering that the tone for discussion has been set, I invite both participants who are in the meeting room as well as those who are online to participate. I'll take the first three questions. Sorry, please state your name and organization before you ask the question.
I would like to thank Justice Zondo. My name is Judge Elita Piri Mwekisa. I'm a High Court judge in Lusaka, Zambia. I would like to thank the two presenters, Justice Zondo and Commissioner Remy Ngoy Lumbu, for the well-presented papers that they've just shared with us. My question is, how does the organization that is sponsoring us, the Africa Electoral Justice Network, and maybe the judiciaries that are represented here, how do you reconcile what we call artificial intelligence, issues of cybercrime related cases when it comes to attacks on the social media that impact on the life of a judge? And I would like to ask a question that probably I'm finding difficult to ask, but I'll still ask it. If a judge feels very strongly that they're on firm ground to continue working as a judge, but they're persistently attacked by society in general, hinging on what Justice Zondo has called issues pertaining to the Judicial Code of Conduct. And this judge, in the meantime, has not even been called by the judicial, in Zambia, we have the Judicial Complaints Commission. And I know other judiciaries, maybe these issues go through the Judicial Service Commission. So if this judge feels strongly that they have not done anything wrong and they persist not on resigning, but in the meantime, there seems to be perceived pressure coming from, I wouldn't mention any, but I'll just say society generally, that they should step down. How do you do, without bringing tangible evidence to justify maybe why that particular judge should not be in the office that they are holding? How do you deal with such a situation? Thank you very much.
Thank you, Justice Mwekisa. Yes.
Thank you very much. My name is Felix Odhiambo. I'm the Executive Director of the Electoral Law and Governance Institute for Africa, AEJN, based in Nairobi. Let me join in congratulating the panelists for very good presentations. Increasingly across Africa, one of the ways of undermining judicial independence across a number of jurisdictions is the withholding of budget or outright underfunding of the judiciary. And this has made it very difficult for judiciary across Africa to expand or even to engage in research to improve access to justice, among other things. And the difficulties or handicap that the judiciary faces is that they have no role in budget-making processes, an exclusive preserve usually for the executive and in certain jurisdictions, the legislature. How can judiciaries in Africa, is there any practical ways or suggestion or recommendation that you can make to help judiciaries across Africa deal with this new and emerging dilemma of massive budgetary cuts? Thank you.
Thank you, Mr. Odhiambo. I can't see properly. Do we have another hand? So it's those two questions for now. We start with the commissioner.
Okay, thank you very much. Je voudrais d'abord remercier ceux qui ont accepté d'interagir avec nous sur ces questions problématiques. Je suis conscient que j'ai utilisé un langage de bois, langage très dur, mais c'est ça le langage des défenseurs des droits de l'homme. Je ne suis pas là pour caresser le gouvernement dans le sens du poil, parce que moi, j'ai été formé pour comprendre que les droits de l'homme jouent toujours contre l'État. Et justement, ils ont été institués en 1945 pour limiter l'absolutisme de l'État. Donc, si je dois avoir un langage quelconque, ça sera toujours un langage dur vis-à-vis des pouvoirs publics. Dur, mais respectueux. Dur, mais respectueux. C'est-à-dire dire la vérité comme elle doit être dite, mais dans le respect des institutions nationales de tous les pays de notre continent. Si je peux rapidement aborder la question de la juge Lakissa de Zambie, que je salue. Sa question est importante. Lorsqu'un juge est menacé, il est attaqué par la société, mais souhaite quand même continuer son travail parce qu'il pense qu'il est intègre. Et moi, par attaque, j'entends les attaques dans les réseaux sociaux, comme vous avez dit, mais ça peut être aussi toute autre forme de menace contre ce juge-là. Je suis déjà content de voir qu'il n'est pas dépourvu de moyens pour se protéger, parce que vous avez en Zambie une commission de plainte qui peut recevoir les plaintes de tous les magistrats qui ont des problèmes dans l'exercice, dans le déroulement de leur carrière. Ce qui est déjà une bonne chose pour protéger l'indépendance de la justice. Et en tant que rapporteur spécial sur l'indépendance judiciaire en Afrique, c'est un exemple qui mérite d'être dupliqué ailleurs, dans d'autres pays, cette commission de plainte, parce que je pense que cette commission de plainte, elle est différente du Conseil supérieur de la magistrature. Je crois. S'il y a une commission de plainte, je ne sais pas si elle évolue au sein du Conseil supérieur de la magistrature ou bien à l'extérieur, mais l'essentiel, c'est que le juge a quand même un endroit où il peut déposer sa plainte et être entendu. Mais deuxième chose, et c'est ça l'importance de cette seconde session, ce que moi je vous ai dit et ce que ma collègue Margaret des Nations Unies, au titre de rapporteur spécial sur l'indépendance des juges et des avocats, ce que nous vous avons dit, le message d'aujourd'hui, c'est quoi? c'est que vous nous avez des canaux d'expression. Les Nations Unies ont un mécanisme, le rapporteur spécial, vous pouvez déposer plainte. L'Afrique a également son mécanisme, le rapporteur spécial ou un juge à travers lesquels, à travers ces mécanismes, lorsqu'un juge se sent menacé dans son indépendance, parce qu'il est sollicité par les pouvoirs publics pour prendre un jugement dans l'un ou dans l'autre sens, surtout en matière électorale, ne l'oublions pas, mais il peut venir nous saisir. C'est à nous maintenant de voir avec le gouvernement, écoutez, tel juge intègre qui fait correctement son travail, subit les pressions de la part de tel général d'armée, de la part de tel politicien, et pourtant, vous l'avez nommé parce que vous avez cru que c'est un juge intègre, c'est un juge indépendant, il faut qu'on le laisse faire son travail. Nous vous surveillons en tant que gouvernement pour que vous le laissiez faire son travail. C'est ça le message que moi je suis venu apporter ici et je suis content que ma collègue des Nations Unies vous ait fait également cette même observation. Donc, il y a des mécanismes pour ce faire. S'il n'y en a pas sur le plan national comme en Zambie, vous devez écrire à la Commission africaine. Si vous ne voulez pas écrire à la Commission africaine et que vous trouvez qu'elle n'est pas non plus crédible, parce qu'il peut arriver que vous nous accusiez aussi de ne pas être indépendants. Nous sommes des experts indépendants, mais il arrive que le gouvernement nous dise aussi, vous n'êtes pas indépendant. Vous pouvez aller voir aux Nations Unies aussi, vous écrivez à Margaret pour lui dire que, voilà, dans l'exercice de mon travail, je suis buté à telle ou telle autre pression sociale, pression politique, pression financière. Je réponds directement à la question du budget aussi, parce que sans budget, sans argent, moi je me rappelle, lorsque j'avais commencé comme jeune magistrat, je n'avais ni ordinateur, ni papier pour auditionner, pour faire des procès verbaux. Tout devait venir de moi, de moi-même et de ma poche. Et je n'avais même pas un salaire, un frais de fonctionnement. Les collègues magistrats corrompus, comme jeune magistrat, ils me disaient, mais pourquoi tu t'en fais? Il faut demander aux plaignants de te trouver de quoi acheter du papier. J'ai dit, c'est déjà de la corruption. Je ne peux pas le faire. Je ne peux pas le faire. Donc, les magistrats subissent différentes pressions. Il faudrait que vos budgets, nos budgets, parce que je suis aussi magistrat, puissent être très bien négociés. Parfois, il y a des juridictions où le frais de fonctionnement arrive, mais le chef d'office, ils en font autre chose. Ça arrive parce qu'on a des courriers qui nous arrivent à ce sujet. Merci beaucoup.
Yeah. Regarding the first question, it speaks to the manner in which the complaint of judicial misconduct against the judges should be managed. You know, the corollary of independence of the judiciary is accountability. So the fact that the judge is independent doesn't mean that the judge is not accountable. The judge should be accountable to the institution, first of all, that he serves, and to the public. Now, if there is an allegation of misconduct against the judge, it's important that those allegations should be investigated by an independent body, which in most cases will be a committee under the Judicial Service Commission. And that committee will consider a complaint, and depending on the outcome and the seriousness of the complaint, if there is a body like a judicial tribunal, then it will be established to deal with now the complaint against the judges. And if during the investigation of the complaint, the Judicial Service Commission feels that the complaint is serious enough to lead to the impeachment of the judge, a judge may be asked to step down. while the complaint is being investigated. So it's very much important that if there's a complaint against the judges, it's dealt with effectively and immediately, because the longer it takes, it affects the judges himself, and it affects also the judiciary, the integrity of the judiciary. So it's important that all the judiciary must have in place the mechanism to deal with the complaint, so that the complaints against the judges can be dealt with expeditiously, and those that are groundless or baseless can be dismissed outright, and the judge can proceed with his normal life and do his judicial function, perform his judicial functions. As regards the second question that was asked by a gentleman from Nairobi regarding the undermining of the independence of the judiciary by withholding the budget. Again, this speaks to the independence of the judiciary. The judiciary must be independent both institutionally and financially. In other words, the judiciary must be able to have a section within itself that is going to deal with its own budget. It should not depend on like in most cases, the Department of Justice. I mean, the judiciary is a third arm of the state. Why should the third arm of the state be required to be under the executive? You know, it doesn't make sense. The judiciary should be independent in terms of institution and in terms of the budget. So there's things of going to the Ministry of Justice for funding. It might create an opportunity for the executive to undermine the independence of the judiciary by either not approving the budget for the judiciary or to cut the budget for the judiciary. Unfortunately, in most cases, the judiciary doesn't have a say in how the budget is being run. You are told that this year you are facing a problem financially, your budget is going to be cut by 20%, and yet you have got the chief justices have got their own budget. They have to make sure that there are adequate books in the library. There are tools of trade like the computers or laptops, et cetera, and the staff that is working for courts are being looked after. So yeah, it's important that we should strive for the full independence of the judiciary and not depend on the Department of Justices or executive to fund the activities of the judiciary. Thank you.
There was another layer to Judge Mukisa's question regarding AI and cyber attacks. Can the panelists respond to that?
Je pensais y avoir répondu parce qu'elle indiquait que face à l'intelligence artificielle à laquelle nous faisons tous face aujourd'hui, cela peut générer pour un juge des attaques dans les réseaux sociaux pour les différents avis que le juge a émis. Et donc, il peut être ostracisé dans la société, il peut être attaqué dans son amour-propre, si pas lui-même, en tout cas les membres de sa famille. Et malgré ça, il se porte fort, il se sent encore plein d'énergie pour pouvoir continuer son travail. Ce sont les aléas de la vie moderne. Toutes les professions aujourd'hui sont sujettes à une critique dans les médias, en commençant par les chefs d'État dans tous les pays du monde. Ils sont attaqués tous les jours du matin au soir, mais ils restent en place. Ils résistent parce qu'ils ont un mandat. Ils ont une mission de continuer à servir les pays. Il en est de même des juges. Lorsque les juges sont attaqués pour le travail qu'ils font, s'ils savent qu'ils sont honnêtes et ils sont intègres, ils n'ont pas à suivre ce qui se passe dans les médias sociaux. Mais parfois, derrière ce qui se passe dans les médias sociaux, c'est parce que les juges ont résisté déjà en amont. Ils ont voulu protéger leur indépendance vis-à-vis de ceux qui ont le pouvoir économique, vis-à-vis de ceux qui ont le pouvoir politique, qui utilisent maintenant les journalistes, on connaît les techniques, hein, pour pouvoir les attaquer. Ça ne sera jamais les gens à qui vous avez refusé de rendre un service qui vous attaqueront de face, mais vous verrez d'autres personnes, vous allez vous demander comment ils sont au parfum, comment ils connaissent cette information au détail près. Ça signifie que quelqu'un leur a donné toute l'information nécessaire. Il n'a pas été dans le secret des délibérés. Il ne connaît pas comment vous avez instruit le dossier. Il ne connaît pas comment vous avez jugé l'affaire. Mais comment il a tous ces détails-là. Et parfois, c'est des attaques avant même que le jugement ne soit produit. Ça signifie que le travail est bon en ce moment-là et qu'il faut continuer à faire le travail, d'après moi. Ça signifie que le travail est bien fait et qu'il faut continuer à faire le travail. Mais maintenant, si vous êtes certain des noms des personnes qui font ça, il faut les dénoncer. Et c'est ce que je m'apprêtais à dire. L'indépendance judiciaire aujourd'hui passe aussi par la dénonciation que eux-mêmes, les juges, font des gens qui font la pression sur eux. C'est ça aussi le thermomètre que nous allons utiliser demain pour voir comment notre justice est indépendante. Un magistrat, c'est très rare. C'est très, très rare de voir un magistrat qui se met debout de lui-même et dire, voilà, dans le cadre de tel dossier, je viens d'être victime d'une tentative de détournement de ma décision, de ma pensée, par telle ou telle autre personne. C'est très rare. C'est très rare. Or, si vous ne le faites pas, ça va être maintenant ceux qui sont victimes du mal jugé qui vont, eux, le faire à votre place, c'est-à-dire en vous dénonçant comme étant des juges impartiaux, comme des juges indépendants. En somme, je suis en train de dire quoi? Protégez votre indépendance vous-même. Protégez-le en amont pour éviter des choses qui peuvent arriver et qui peuvent nuire à votre carrière en aval. Mieux vaut qu'un juge dise, je me dessaisis déjà de ce dossier, par exemple, parce que j'ai subi des pressions. Ça, c'est aussi une forme de protéger l'indépendance. Mais quand vous ne dites rien et qu'à la fin, on vient nous dire que ce juge a été impartial ou non indépendant, c'est très difficile de croire en ce juge.
Thank you. This brings us to the end of this session. Let's give the presenters another round of applause.
Thank you very much, Justice Kawimbe. I knew you were going to be efficient and that you're going to be able to finish the business within the time. So I think this takes us to a healthy break. And thank you, presenters. Thank you, audience, for effective participation. So we will meet here again at, is it 4 p.m.? Yes. Yeah, we meet again at 4 p.m. That is in about 20 minutes time. Thank you. So it's a tea break. Thanks, Justice Kawimbe. Thank you, Professor. So as they step aside, the person who was appearing in our program as the chair for the next session, Hassan Shire, he couldn't make it. He just couldn't make it from Ethiopia. So there's Skanyisiwe Sebata, a resident of Victoria Falls who is with us, who has kindly agreed to be the session chair. So, so she's going to present herself at 4 p.m. Thank you. Honorable Chief Justices and distinguished guests, we've been doing very well. We're going to get into the final session, I think, of the day. And with Skanyisiwe Sevata, who is a Victoria Falls resident, but she also is the communications and advocacy officer for an organization called Africa Initiative for Women Human Rights Defenders. And so it's a civil society session, essentially looking at the role of civil society in advancing human rights and good governance through electoral justice. And without wasting too much time, let me ask Iska to take over and preside over the session.
Yes, okay. Good afternoon, everyone. As Arnold said, my name is Kangisiwe Sabata, and I'm the head of advocacy at the African Initiative of Women Human Rights Defenders, where we're working to safeguard women human rights defenders in Africa and beyond. And I'm going to be chairing this session titled The Role of Civil Society in Advancing Human Rights and Good Governance Through Electoral Justice. And I'd just like to thank you for the opportunity to chair this session. And please allow me to ride on the protocol that's already been defined and observed throughout the day. The principal focus of this session will be on the protection of human rights in the context of electoral justice. While the approach to the protection and promotion of human rights is intersectional, the session will focus on the specific civil and political human rights that are underpinned by the electoral justice and fairness, and explore the crucial role of civil society organizations in monitoring the process and enhancing voters' understanding on the election process and denouncing abuses. The session will also consider how electoral adjudication, whether occurring during the prime electoral periods or otherwise, impacts the advancement or, in unexpected cases, repression of human rights. All right, so joining me for this session is Dr. Tinenenji Banda. If they're in here, please may they make their way forward. Thank you. And then Bukola Idowu. And then Mr. Tawona Manyisa, who's going to be joining us virtually. All right, so while they make their way, unfortunately, Dr. Justice Mabengidze could not join us for this particular session today. But while they make their way forward, I'm just going to introduce Dr. Tinenenji Banda. Is from Southern Africa Institute of Policy and Research, SAIPAR in Zambia. And then Bukola Ido is from Kimpact Development Initiative, that's KDI in Nigeria. All right, so we're just going to make this one session. So I'll ask Dr. Tinenenji to please just go ahead and make their presentation, and then straight after, if you could also then, Mr. Ido, please make your presentation as well. Thank you.
Thank you, moderator. I'd like to recognize the presence of the Honorable Chief Justices, your lordships here present. I'd also like to recognize the presence of all judges here present, currently serving and retired. I'll also stand by all past protocols. So I want to thank the network for giving me this opportunity to share my thoughts and perspectives. Singularly, I know this is a very broad panel discussion, but if you look at the panel topic, it says, in defense of human rights, a critique of minimalist and activist approaches in electoral adjudication, and that will be my singular focus. So in reflecting on this topic of judicial minimalism and maximalism in the context of electoral adjudication, I was struck by the lack of agreement and consensus on what those terms actually mean. So it's therefore not possible for me to issue a blanket endorsement or a blanket condemnation of either approach. On the one hand, you have the minimalist judge. When considering an electoral petition, the minimalist judge, in theory, will be unintrusive, they'll be literal, they'll be textual, value neutral, ideologically neutral, avoid theoretical considerations, avoid bright lines, avoid abstractions, not do too much with too little. Essentially, the judge practices judicial restraint and stays on the so-called narrow path. On the other hand, you have the judicial activist who is a maximalist. And this may include striking down legislation and executive action when undertaking judicial review. It certainly includes going beyond the narrow confines of ordinary and plain language in a statute and infusing broader societal considerations and policy considerations as well. So both approaches, as you know, are quite controversial and are fraught with challenges in electoral adjudication. The challenge with minimalism, of course, is that the terms that courts are called upon to interpret in electoral petitions are so abstract, too abstract, in fact, to have a single and narrow, readily available interpretation just by looking at the text. Of course, electoral adjudication requires a very high level of abstraction, where courts are called upon to determine which categories of malfeasance in electoral practice deserve this higher level of scrutiny. And of course, they have to do so within the context of the controlling statute, which will determine materiality thresholds and whatnot. Of course, the maximalist approach also has its own dangers because courts generally try and minimize their footprint in electoral contestations for various reasons, but particularly courts are generally aware of the concerns we were discussing this morning about the judicialization of politics, etc. But it seems to me that when it comes to the unique features of post-electoral contestations on the continent, contemporary thinking on these minimalist, maximalist approaches somewhat fall flat and are really put to the test because in many African jurisdictions, the sheer volume of election petitions, I mean, running into the hundreds. I know in Nigeria last year, there were 1,200 petitions filed. So that volume means that elections are actually determined in court and not at the polls. Now, not only does this put enormous strain on overburdened judiciaries, but it also makes judiciaries the site of political contestations, which should belong at the poll. But more fundamentally, and this is the main point I'd like to make today, it takes courts away from their core business in electoral disputes. So the role of the role of the courts in electoral disputes is not to gratify the needs of disputants or political parties, but to explicate and give force and voice to the values of national constitutions, to the values of controlling statutes, and in so doing, make pronouncements on the law, the making of law, the breaking of law, the limits of law, the shaping of law, the development of law, and how it reflects societal expectations and how it can meet, or whether it can meet, changing circumstances and societal mores. But when you have a judiciary that is bogged down with hundreds of petitions, thousands of petitions, this does not lend itself to this high impact public exposition of the law and, principled modification and change, as the case may be, of electoral law. And then you find the adjudicative process simply becomes iterative because judges are having to to process these high volumes of cases within very strict time bounds, which are in a lot of cases constitutionally mandated. And for me, I think what is interesting about this contested space of electoral disputes is that they seem to override the disincentives to go to court. Okay, so we're highly disincentivized to go to court. Just intuitively, nobody wants to go to court. I mean, the cost implications, both in terms of time and money, the cascading costs, social, emotional, freedom of movement is restricted when you're tied down by court dates, etc. And because of these disincentives, precious few cases actually end up in court. I mean, anecdotally, I would say maybe 95%, that's just an anecdote, 95% of disputes will never come into the formal court system. Okay, they're filtered, managed through an informal a mechanism of dispute resolution. But with electoral disputes, this is turned on its head, and you find this interesting wrinkle where the majority of electoral disputes actually end up in the formal court system. And so I worry that the responsibility of ensuring electoral justice is placed disproportionately on the courts. And I think we need to question the conventional wisdom that electoral petitions are always democracy enhancing. I think that was the controversial wisdom when African courts began to hear electoral petitions, and they were democracy enhancing. I mean, you look at Kenya, you look at Malawi, but I think that that still is the case, and courts do have a crucial role in upholding election integrity. That is not questioned, but I think that petitions do not always enhance democracy. They actually can work to undermine democracy and do contribute, I think, to that democratic hemorrhaging we were discussing earlier today. So finally, in reflecting on the conversation this morning, I think the use of electoral petitions to achieve strategic political goals, to overcome the dysfunctions of electoral systems, actually amounts to a weaponization of the judiciary, a misuse of the judiciary. And more importantly, the judiciary is not able to play that exemplar role where it is making these high impact public pronouncements that shape the trajectory of the law and that espouse our most deeply felt constitutional values. And as I think the theme of the conference is, and as we heard in the keynote address, entrenching constitutionalism. The role of the courts in electoral disputes is entrenching constitutionalism, entrenching the rule of law. And that is not possible when you're processing hundreds of petitions, I think is the synopsis of what I'd like to share today. Thank you.
Good afternoon. I want to observe all protocols. I am from Nigeria, so I am used to all protocol duly observed. You know, in an event, you can have as many as a lot of protocols. So that I don't mix things up, I want to respectfully say, my Lord Justice, is all protocol duly observed. I am happy to be here today, and I'm going to quickly speak and show and draw lessons from Nigeria, and then speak towards that, the role of civil society. I work for an organization called Kimpact Development Initiative, and our focus and what we do is on elections. And we focus on two major areas. Number one is electoral justice, and the second one is electoral violence. But today I'm going to just focus on electoral justice and our work, which we have been doing on electoral justice, supported by International Foundation for Electoral System over the years. So, as a civil society person, permit me to represent the people. And because I know my Lord Justices are here, the judiciary, High Court judges are here, Court of Appeal. So permit me to represent the citizen, which I work among. And we have heard a lot of papers today that talks about what the social media is doing, the fake news, attack, cyber attack, and everything. So I represent those people who have been attacking you. So you will allow me to bring this conversation from their dimension, from their perspective, so that we can have a point. Because if they are attacking, there must be a reason. The reason may not be genuine, but possibly there may be one sense or the other from it. So in Nigeria, we had, after 2023 election, we had 1,209 petitions. Such a huge amount of petitions. And let me say, the law, the Electoral Act, and the Constitution of Nigeria allow that every election, you have to set up, at least 30 days before the election, set up the tribunal. So we have the election petition tribunal manned by judges to sit and adjudicate just for 180 days after the election. After that, for governorship, for governorship, State House of Assembly, and legislative houses and National Assembly, you have to go to, if you are not satisfied with the tribunal, you go to the Court of Appeal. But only the governorship and the presidential election were allowed to go up to the Supreme Court for post-election litigations. We also have 180 days for the court to sit on pre-election cases. I did not come with the data of pre-election cases, but I tell you, the pre-election cases was over 1,800 after party primaries. And out of 1,800, 800 of them ended up in Court of Appeal. 400 of them, 402 of them ended up at the Supreme Court. That is pre-election that have to be dispensed with before the general election. After the general election, you will now start post-election litigation. I'm driving somewhere, my lord. This gives you the trajectory of where we are coming from 2003, our petitions. But you find out that it keeps increasing. And I'm saying, using this data to point to us that in Africa, whether we like it or not, it looks like this is going to be part and parcel of our electoral process. Litigation looks like it has come to stay. So if we are thinking that we are going to reduce, or we are coming to a point where there won't be dispute, I don't think it's going to happen, because it keeps increasing day by day. And that is why I am so happy what the network is doing, that we have a network about this. It speaks to the issue we have at hand. And in fact, we also have some countries who have electoral courts now. It speaks to the fact. Now, look at this data. The total number of seats, elective seats, after contested for in 2023 election is 1,408. 58% of them, of that seat, were contested in court. 58%. Of course, there are loads of reasons, but I need to move faster. Now, I said something earlier. This is just to point our attention to it, and I think my colleague also made mention of it. The inflow of petitions from the politicians. And for instance, in Nigeria, in 2022 to 2023 legal system, you know, over 7,000 appeal, 3,600 motion were filed in 20 divisions of Court of Appeal. However, the court itself, Federal High Court itself, have over 39,000 cases pending in 2023 that were abandoned one way or the other for the judge, because the judges were pulled out to sit on election petition tribunals. Because it's time bound, 180 days. So, in fact, in some instances, not even in some instances, that is the reality. We did not even have enough judges, so we have to get judges from the magistrate court. We also got judges from the Sharia court. Everybody did crash course to go and sit on election cases. And that was the truth, because how do you dispense 1,208 cases in 180 days? And you must bring evidence and everything. So that is the reality of what we have. And this is for the data for 2022, what affected the pre-election. But my lord, let's quickly go on. What I am now trying to say is that whether we like it or not, there is a huge impact on regular courts. And that is just the truth. For instance, in Nigeria, 180 days to the election, you are dealing with pre-election issues. After the election, you are dealing with post-election issues. So in any way, whether you look at it, 180 days is approximately 6 months. So you had like about 1 year to do election issue. And civil cases, criminal cases, some of them are pending. And permit me to quickly give you this. While we were monitoring in 2019, Nigerian police, before the thing, arrested some people, took them to court, just by the way, to tell you this story. And then when they got to court, what happened? And they reminded the people arrested, they reminded them in the correctional facility. Out of them was a woman. So the hearing to get their bail was fixed, I think like about 4 weeks later. Now, by the time, or 3 weeks, I think, yes, 3 weeks. By the time 3 weeks came, the judge sitting, who is supposed to hear that case, a bail application, has gone for election petition tribunal issue. One of the women arrested was pregnant. Before the man's finished spending 180 days and come back, the woman delivered in the prison. So he was in the prison for just awaiting trial. So these are some of the impact. And you have seen, for instance, in Nigeria, the magnitude of cases that have been abandoned and that is why some of us are advocating for electoral court, which some countries have. I remember we tried to contact Honorable Justice Zondi to come and speak on this in Nigeria. But this is the reality. I think we should, this forum should make probably strong statement that this is more needed. Or else, while we are adjudicating on election issue, regular courts are likely going to suffer. And we are also seeing that if you have this, possibly, we are going to have expertise. In Nigeria, we have what is called industrial court. Any equivalent to the High Court, any cases after industrial court, they hardly get an appeal because they have built specialization and they give thorough job. Probably election cases have to be done like that. Not picking somebody and quickly do crash course and then say go and adjudicate on election issue. So, but the issue is, speaking from the people, why do we have this kind of influx? And that is why I said, this is what citizens believe in, that whatever the ballot cannot give you, the court can give you. Whether they are right, whether they are wrong, then we assess our judgment. And that is why you see a lot of cyber attack. Somebody did not win at the court. And I think it was Chief Justice that said this in the morning, that court should not be where people seek to win an election. But whether people, they did not win and they rush to court. When they get to court, we have seen that in the past. When they get to court, for instance, that in Nigeria, there is a governor that is called Supreme Court governor. What happened? He came fourth in the election, but the Supreme Court declared him the winner. Fourth in the election. But based on technicalities, the second person, based on technicalities, could not assume the position. The third person, they said he was not joined in the suit. And then the fourth person became the governor. Yes, you can Google it, Imo State. That is it. So now I'm talking 2019. So that arose the anger of the citizen. How can over 500,000 people go and kill inside the rain, in the sun? And at the end of the day, after 9 months, 5 justices sat down and said, this number 4 is the winner. That is the issue. So that gave birth to most of the attack we have been seeing. Whether the process of the law is genuine, but my Lord, do you think we citizens, how many percentage of us are lawyers who understand the laws? And this is the issue. So people believe, oh, these politicians, whatever the ballot cannot give them, they can get it in the court. So before you hear the petition, they start the attack. Before you give judgment, they start the attack. And permit me, so this is the issue. And how do we solve it? And I align myself with what Chief Justice said today. Court should not be where politicians should be winning an election. So which one is stronger, the ballot or the court? And how do we find the balance? So I think, let me quickly rush and hand it. Now, if you look at the disaggregation of petition in Nigeria, not qualified to contest is just 17% of that 1,209. Lack of majority of lawful vote cast, 34. And then non-compliance with Electoral Act, 47. If you put the two together, and these two, but is not an act of the judiciary or anybody, but it borders on the process of the electoral management body. And that is what they are challenging. So with the inefficiency or efficiency of the election management body, they have successfully dragged the court into the arena. Because what we have seen in Nigeria is this. In fact, the chairman of the electoral management body in 2019 said, he declared the result. He said, party that are not satisfied, go to court. And people went to court, 1,209. They went to court. Now, what has happened is this. The burden was taken from the election management body, pushed to the judiciary. And what it means, again, is this. According to our law, it is the person that is alleging, petitioning, that should prove his case. In fact, the election management body don't have the burden of proof. So it's easy to say, go to court. So how do we bridge this gap? And that is what citizens don't really understand. Permit me to now draw on this. What we have seen, the negative perception of the judiciary and the spread of fake news. These are just pointer when we were doing our research in Nigeria that really caused it. At some point in the presidential election petition tribunal, we have 5 petitions came from 5 parties. But 3 of them, I think 2 withdrew, and then 3 of them stay. Now, the 3 of them, they were addressing the same thing. So the court decided to consolidate. My Lord, sir, the citizen did not understand what consolidation means. So what happened? All manners of interpretation on social media. Now, the lawyers were very smart. They kept quiet. Nobody educated anybody. Because they are either for the petition, because they are watching where the conversation will go, so that they can also swing public
opinion to their side. So if you lose the case, they will have, they know. So so it will not be like, oh, I could not prove my case. Even the citizens know that the court. So they were so careful. So with that, all manners of interpretation. Number two, there was no clarity on that 180 days. The Constitution says 180 days. So people did not know if public holiday is part of it, if Sunday is part of it, because it is expected to be sui generis. So people did not know all manners of interpretation. And let me now, so that I don't waste time and then quickly leave. This has affected the spread of fake news and attack. Why? Because the judiciary, you believe that you can only be seen and not be heard. And I want to say, permit me respectfully, to ask if that assertion is still much more relevant in 21st century. In the age of digital activism, in the age of social media, one of the things is that maybe we should have a communication desk. We should have a social media handle. We are not expecting the judges to come and be talking, no, but at least the court, somebody representing the court, should be speaking. So when the court keep quiet, people give interpretation, and this fake news keeps spreading. And in fact, at some point, we now come back to begin to react, to debunk, but the news have gone far. We can be proactive, and that is one of the things citizens saw, because we did not, from the civil society, the court were not speaking to what this is all about. This is what we are doing. In fact, for the first time in Nigeria, people were clamoring that the petition process should be televised live, because they want to see, they want to follow. Okay. This is an example of a tweet. This person is even a lawyer, said the judiciary cannot exceed the time frame stated in the law, no matter what happened. The 180 days we expire on the 19th of August, 2023. Why the wait to give us date for the verdict? Nigeria are anxiously waiting. All eyes on judiciary. That was the hashtag. All eyes on the judiciary. But what am I trying to say? And 180 days, the court gave the judgment September 6. 180 days ended September 6. But this man calculated 180 days to be 19th, and it was spreading like that. Then it became an issue. Oh, it's because they were trying to change the judgment. That is why they were trying to change it. However, the court did not come out and say 180 days, we expire with this. So they allow information to be going. So, my Lord, what is my proposal? We can be proactive in terms of communication. That will douse some of these things. Security of the judges. Our observation shows an increase in cyber attack and intimidation of judges. This is an example, cyber attack. They pull the picture of the judges together and they say all eyes on judiciary. In fact, I don't know, maybe I came with it. Look at this. That was the chairman of the panel. They put the picture of his grandchildren and said, look, this is the man. If he... So, at some point, they did billboard. They went to put it in front of the Court of Appeal in Abuja and said, all eyes on judiciary. So, what am I trying to say? We notice that. Let me give you this analogy. That hashtag, all eyes on judiciary, within a month, within 2 months, reached 35 million Nigerians. Hashtag, all eyes on judiciary, reached 35 million Nigerians. That the judiciary, and when we did sentiment analysis, the blue one shows the negative. So what does that mean is that out of that 35 million, like this kind of analysis shows greater number of things that accompany that hashtag were negative. Oh, in fact, some people will be talking as if they were there when it happened. They will say, oh, somebody, in fact, it has come to our notice that justice so has just been given a plot of land in Banana Island just to upturn the judgment. And you will ask the person, are you there? He said, I had. This is somebody has been given 35 million naira. How did you know? I had. So the cyber attack was much. That led to even relocation of some tribunal out of the state because of security issues. Let me land on this, and this is my concluding thought. The 1,209 petition, only 206 were withdrawn at some point. Out of 1,209 petitions at the end of the day, only 102 won at the court. 901 lost. 901 lost. Now, there is an academic analysis to this now. Number one, for majority to lose, some school of thought believe the court had validated the election. And some people, at the other school of thought says, look, the whole process of judiciary is difficult to prove your case. And that is what Professor was talking about in the morning, because our judgment to the citizen, for us in the citizen, as civil society, during the time of election, you go out, they say, come out and vote, go and register, it is your right. They say, come on, keep short. You want me to vote? At the end of the day, 5 people will sit and declare number 4 governor. So you can see how that, to just confirm what Prof said in the morning, how that has affected voter turnout. So our action, people just take it, okay, no, it can affect that voter turnout, and that is it. So lastly, the issue we have seen here is that on the issue of the burden of proof. Should it be swinging? If truly we agree, and that is what citizens don't understand, if truly we agree that election issues are sui generis, the class of its own, we have seen an instance, and I'm going to make it practical, my Lord. We have seen an instance in court where there is an electoral act. The judge will go to the criminal act. We go to the evidence act outside the electoral act to give a judgment. I give you one that the citizen could not understand from the election. People that supported Obi, if you know, Obi was popular and the youth thought he's going to win. What happened? During the case, the lawyers will say, my lord, I want to call witnesses, so. They call the witness. The witness will tender evidence, speak to it. At the end of the day, the panel, the judge will say, okay, admitted. They admit it, label exhibit, so. At the end of the 180 days in their judgment, they threw all the evidence away. Why? Because they were not front-loaded at the beginning. And citizen was not asking. You know they were not front-loaded. And you are accepting. And you are labeling it. And we are happy. Not knowing that, front-loading in Nigeria is that you will have presented the cases, the people you want to call at the beginning. That, okay, I'm calling this person, so that the defendant will also know. And things, they say you are calling these people. And the people, when they went to the appeal court and Supreme Court, they also have the power to subpoena anybody. But that is it. All the technicalities, citizens don't know. So I am ending on that point of that technicalities. And the other one is the aspect of conflicting judgments. There is a way they affect. In fact, in Nigeria, state houses of assembly election ended at the appeal court. It doesn't get to the Supreme Court. The appeal court gave a judgment and sent like about 21 state of House of Assembly packing. The same grant for the governorship that went to the Supreme Court, the Supreme Court affirmed. So now, the issue in Nigeria now, you can Google it, Plateau State, is the Supreme Court judgment. We all believe it supersedes that of the appeal court. However, 180 days, the time has elapsed. The judgment terminated at the Court of Appeal, but it contradicts. As I'm talking to you, there's supposed to be a by-election in some local government in that place. The place is already charged with violence because they felt cheated. What are you going to do? The Constitution says it terminates there, but there is an error. How do we do that? It has issue on citizens who go to queue inside the rain, inside the sun, to cast their vote. The last one I was saying, this aspect of technicality. My Lord, let me give you a practical example. Judgment, on the day of judgment, for the cases of, and I'm saying this in case you want to Google, Adeleke and Oyetola in 2018. They had the whole process was going on. And at the end of the day, when judgment was given, it was a panel. So the man that read the lead judgment, why other judges will say, I concur to that judgment. And the man that read the judgment, and Oyetola was the governor, was the one that election management body declared as the governor. But Adeleke challenged the case that he did not win. But that tribunal nullified the election of Oyetola and declared Adeleke winner. And Oyetola went to the Court of Appeal and said, not on the ground of the substance of the issue, that not on the ground that I won that election, but he went to the Court of Appeal to say, please, Court of Appeal, nullify that judgment because the man that read the judgment was not there when vital evidence was given. He was absent. And truly, there was 3, but 2 can sit because they form a quorum. But that man, whether he had malaria, we don't know. Till today, nobody knew why he was not on seat when evidence was given that time. Till today, we don't know. And that also turned to, because people were now saying, National Judicial Commission, NJC, who oversee and punish and look at petition against judges, say something, ask the man, you were posted to go and empanel, where did you go that you are not there? Till today, nobody knew whether he got sick leave or whether his grandchild was giving birth. Nobody knew. But all we knew, he was not there. And they approached the appeal court. And when they approached the appeal court looked at the technicality, the process, the flow, and said, truly, you were not there when it was given. And therefore, that judgment cannot stand. Okay? Adeleke now went to the Supreme Court. Supreme Court affirmed what the appeal court said. And that was how the man continued as the governor. And the question now is this. People are now asking, from Court of Appeal to the Supreme Court, the issue that validated the election is that the man that read the lead judgment was not there when evidence was given. So the question is, the man, did he win the election? Nobody knew till today. Did he cheat? Nobody knew till today. What was the judgment based on? He was not there. So people did not understand the technicality. My Lord, can we fix some of this technicality and treat the case as it is so that citizen will not, our citizen will follow that judicial maxim that says justice must be done. Not only must be done, must also be seen by laymen to be done. Thank you.
Thank you so much.
Thank you so much, Bukola and Chinenenji. Yes, let me go. All right, thank you so much, Bukola, for such passion and for representing the voice of the citizens. Thank you, Chinenenji, for your presentation and breaking down those two approaches for us. Okay, so now we're going to be joined by Mr. Tawona Manyisa, who is an election and governance expert and is joining us virtually.
Good afternoon. Can you hear me? Can you confirm if you can hear me?
Yes.
Thank you so much. Just give me a few minutes, a few seconds just to share my screen and confirm if you can see my screen. Okay, I hope you're seeing my screen. Hello? Can you hear me?
Those who are online, we can see your screen. I don't know at the venue.
Okay, I'm saying, okay, you can hear me as well, right?
Yes, but I'm online.
Okay, beautiful. Those in the venue, can you confirm if you can hear me or you can see my screen?
Yes.
Oh, thank you so much. Thank you very much for this opportunity, and I hope all the protocols have been dispensed with. So I'm not going to go into the protocols, but I'm excited that I'm going to be joining you about virtually. I would have loved to be present for this session and to be among the distinguished delegates. Especially those of the bench. It was always my desire as a young boy to be a judge. And I think this is the closest I can be. So for the session, please can you refer me to Judge Mwanyisa just to honor me and to humor me for the ambition that I had that was never fulfilled. So our session today is going to be looking at alternative electoral dispute resolutions and how they complement the formal election dispute resolutions. And I think some of these have been broken down in the morning sessions, and discussions also have been conducted in terms of some of the vehicles that are available to address electoral disputes. But what I just need to highlight from the start is that election disputes are a very unfortunate reality of elections, especially where there's competition, and they're also very inherent in democratic processes. And when such disputes arise, the stakes tend to soar, and as they touch on the core principles of power transfer and public trust in electoral processes. And by their very nature, elections are also a battleground for varying interest, where candidates invest significant resources as well as emotions. Incumbents, that is those that are in positions of power, they strive to retain power, while those that are challenging to gain it create a very fertile ground for disagreement to sprout. And this is the nature of elections, not necessarily only in Africa, but continental-wise. And you'd find that electoral disputes, as I indicated, are inevitable and are a byproduct of competition in all the democracies. And these disputes can erupt throughout the electoral cycle, not only on voting day, in normal case voting day, but there are also instances of election disputes in pre-election period, the election period itself, and the post-election phases. And the common flashpoints for disputes include disruptions during campaigns, disruptions during boundary delimitation issues, voter registration, irregularities, candidate nominations, voting procedures, and also the acceptance of results at the end of the electoral processes. If all these are left unaddressed and are poorly managed, these disputes can cast a long shadow, eroding public confidence in the integrity of the whole entire electoral process. So I thought I should set this tone at this juncture in terms of confining and locating where electoral disputes normally occur within the electoral process, so that at least it then assists with the discussion as we go into the discussion as it were. Okay. So to address these challenges, a multi-pronged approach is normally used or employed, and normally it leverages on your both formal as well as informal dispute resolution mechanisms. And formal processes, while crucial, can sometimes be overwhelmed by the sheer volume of disputes, potentially leaving some unresolved justice, which is also delayed in terms of electoral processes. And alternative dispute resolutions stepped in to fill the gap. I think I did not sit in the presentation by Tindele. I worked with her on a project on Zambia election dispute resolution. And one thing that we noted when we were working on the project was that the formal dispute resolution was actually overwhelmed to the extent to which courts were unable, in most cases, to meet deadlines and to dispense off with cases. And this created bottlenecks, and in most cases, also resulted in justice delayed. And this is where your alternative dispute resolution comes in terms of taking off that burden from the formal dispute resolution mechanism and deal with cases at local level. The EDR offers, like I indicated, parties involved in an election dispute flexible and non-adjudicative methods to reach an agreement outside the formal court system. And this includes negotiation, it includes mediation, they also include fact-finding and arbitration. And these approaches aim to find solutions that satisfy both sides. Often they are faster, they are more cost-effective than the traditional courts. And please, I underline, I'm not in any way saying that the formal dispute resolution mechanisms are a failure, and I'll explain later as I go into the discussion. The existence and use of these alternative methods seems to suggest in some way that the formal processes do not work, and hence we have the alternative mechanisms available to deal with electoral disputes. Again, it's important to note that ADR does not replace formal processes, rather it complements them. And by providing an alternative avenue for dispute resolution, the alternative dispute resolution mechanisms, they help to streamline the system, but also ensuring swifter justice and reducing the burden on the formal courts. And this is very important because what it does, it leaves the burden that is normally sits with the formal courts. And some cases are so petty to the extent to which they cannot be adjudicated at the level of the formal dispute resolution mechanism. One key advantage of disputes is their flexibility and speed, which means they offer a quicker resolution compared to the often slow pace of the formal court systems. This, coupled with its cost effectiveness and accessibility, it makes the ADR an attractive alternative. And the accessibility I'm referring to refers to the ease with which aggrieved parties can file complaints, and they can access those courts. Factors like legal standing complexities of the formal system, language barriers of the formal system, the gender disparities of the formal systems are actually removed if we locate electoral dispute resolution mechanisms at the very local level, which is within the framework of the alternative dispute resolution. So, for example, establishing local conflict management committees in countries like South Africa, Mozambique, I think South Africa, Zambia, and Malawi is proven very effective in resolving local disputes and preventing politically motivated violence. And we are not saying it eliminates, but they tend to locate the violence where it is located, that is at local level, and they tend to deal with those. And this success stems from their accessibility and their ability to address issues within the community and fostering trust and understanding. And I emphasize again that they tend to play a complementary role with the formal dispute resolution mechanisms. So you'd find that the formal court system also often at times fail to deliver justice within stipulated periods of time. And this failure can stem from several factors, including prohibitive costs, your complex procedures, limited access, and legal resources. And one key advantage, and this is where the EDR mechanisms come in with one key advantage, it's their affordability. And unlike traditional litigation, which can incur exorbitant, expensive costs due to court fees, lawyer fees, evidence collection, the ADR mechanism typically follows a faster and a most effective, cost-effective process. So what it does that this makes it accessible to a wider range of individuals and parties. And furthermore, navigating the complexities of formal legal system often requires significant financial resources, which do not rest so with everyone within the societies. So you'd find they can only now be accessible to parties with greater economic means that can afford legal expertise, they can secure evidence, they can mobilize witnesses, and ultimately increasing their chances of success. However, with EDR mechanisms, they can level the playing field by providing simpler and more affordable way to resolve disputes. So beyond accessibility, EDR also boasts significant flexibility. By offering distinct advantages over traditional court systems. Firstly, unlike the rigid court schedules, EDRs allows for mutually convenient proceedings, accelerating conflict resolution, and easing the burden on the formal system. And this flexibility also extends to tailored remedies, including agreements which are not necessarily foreseeable by courts, such as adjudications of campaign routes, usage of venues, tearing down of campaign materials. These are issues that can be dealt with at the local level without necessarily burdening the formal court system to a large extent. And they are also known, EDRs, for their preservation of relationships and improved communications between parties, and potentially leading to more sustainable solutions at local level. And allows for addressing both the legal and non-legal concerns, which means crafting solutions that our conventional court system may not really offer to a large extent. And this can lead to more comprehensive and satisfying outcomes for all parties, especially at the local level. Because remember, these are people that are living in communities. And in most cases, formalized systems tend to be removed from the local level, and they tend to be very much elitist to a large extent. Whilst these disputes can be resolved at local level without necessarily burdening the formal court system. But I'll come to that in terms of elaborating what cases can actually go to informal dispute resolution, so that at least we can draw a distinction between the two. Whilst alternative election dispute resolution offers these numerous advantages, there are also some limitations which normally hamper their effectiveness. EDI or EDRs may not be suitable for every dispute. For example, the dispute involves a matter of public interest. It may be more appropriate to have a court judgment that sets a precedent. And cases of criminal nature, such as violence and theft, will require the involvement of law enforcement agents and formal criminal court systems. And one of the things that we discovered when we were working on the Cedros project for Zambia was that mediators within the informal dispute resolution mechanisms tend to lack specialized knowledge of electoral laws and the intricacies. Potentially, it then leads to the hindering their ability to handle complex disputes effectively. So imagine a mediator trying to navigate a dispute over gerrymandering without the understanding of electoral district laws. This lack of expertise may lead to misunderstanding, unfair outcomes, and loss of trust in EDR process at local level. There's also the tight window, and I've actually noted that this is across the region. There's this tight window before elections, which often leaves inadequate time for thorough preparations and robust dispute resolution processes. Often, informal dispute resolution mechanisms are quickly put together just before an election. There's no time for training. There's no time for conscientizing the masses or the voters or the parties on how to access those dispute resolution mechanisms. And with limited time, mediators may not be able to fully investigate the facts, they might not gather evidence, and they might not hear from all political parties. For example, in Zimbabwe, the multi-party liaison committees, which are part of the EDRs, they are constituted as and when the date of election is proclaimed, as well as the nominations are done. And this is way into the electoral process, and it actually does not take into consideration issues that have actually happened or occurred before the election. So in this case, it can lead to rash decisions and the higher chances of errors in mitigating those disputes. And this lack of mediators' specialized training in electoral dispute resolution may also render the EDRs ineffective. And perhaps the greatest challenge of EDRs is the limited enforcement powers. So some agreements made by EDR might not be easy to enforce at court or in order when they are given. And this is a problem that we have actually seen with codes of conduct, particularly where they are designed in such a way that they do not have enforcement mechanism to the extent to which political parties tend to ignore them and they do not adhere to them. But we have also seen a transition in some jurisdictions where codes of conduct are now enacted within the Zambia is one country, for example, that is actually done so. So the lack of authority to enforce agreements reached through EDR can undermine their efficiency. And this is coupled with the proactive limitations. So EDRs lack what we term proactive limitations. And these mechanisms may fail and are limited in power to proactively address potential disputes or intervene in situations that are escalating towards violence in the build-up to elections. And this is a limitation that is normally noted with EDR. Another potential issue related to EDRs as well is their vulnerability to external influence, which potentially compromise their effectiveness. So this influence can come from various sectors, undermining the neutrality and impartiality for fair dispute resolution by EDR mechanisms. And furthermore, a lack of data on EDR cases and outcomes can also hinder the assessment of their effectiveness. I referred to the CEDROPS project in Zambia, and during this project, we encountered limited information on activities and caseloads of conflict management committees. And this could indicate insufficient training on record keeping or broader lack of support for these mechanisms. And you know, most of these, what we noted as well is that countries and EMBs are merely putting them there, and they don't thoroughly support them with resources that are required to dispense of with cases and resources that are required even to archive their own judgments to a large extent. So without comprehensive data, it is challenging to measure the impact of EDRs and identify areas where we can improve them. And addressing these concerns around influence and data collection is also crucial in bolstering the ability and credibility and effectiveness of EDR mechanisms at local level. I'm winding up. I just needed to highlight 2 or 3 issues before I conclude. And one of them is that maximizing the potential of alternative dispute resolutions is also and ensures its successful implementation, and it requires key challenges to be addressed. The very key challenges that are highlighted above need to be addressed, and key and central to their success is in the specialized mediation that is there and the building capacity of mediators. Targeted trainings for mediators and presiding officers in electoral law and dispute resolution skills must be provided if they're going to be successful. And this training equips them with necessary knowledge and expertise to handle complex cases fairly and efficiently. It's also important to foster collaboration between EDRs and judicial systems. So judges should be aware of EDR mechanisms and their potential to alleviate caseload by resolving several specific disputes effectively at local level without burdening the formal dispute resolution mechanisms. And lastly, data and collation of evaluation and is key to resolving some of the deficiencies that we identify in EDRs. And robust data collection and evaluation systems to track EDRs, caseloads, outcomes, and inputs must be implemented if they're going to be successful. And this data provides valuable insights for continuous improvement and ensures accountability within the mechanisms as they are evolving. Lastly, also, as I conclude, it's undoubtedly EDRs mechanisms, they play a very, very critical role in resolving electoral disputes at local level, and their ability to provide quicker, more accessible and cost-effective resolutions compared to the formal systems make them crucial for ensuring free and peaceful elections. And to maximize their efficiency and effectiveness and sustainability, this valuable tool needs investment in resources in their developments, and ongoing support is very paramount. They are going to play that leading role in terms of lessening the workload of the formal judicial systems. And by prioritizing these investments, we can empower EDR mechanisms to play an even more critical role in safeguarding the integrity and fairness of the electoral process at local level. My presentation does not necessarily take away the role of formal dispute resolutions. What we are saying is there's that complementarity that is available between the formalized election dispute resolutions as well as the informal dispute resolutions. And to a large extent, by building capacity of the informal dispute resolutions, we are also lessening the burden of cases of the formal dispute resolution. I mean, in some countries that I've worked in, you find cases going beyond 5 years on electoral dispute resolutions that have not actually been resolved. And those are cases that can actually be resolved local level and judgment not being issued over a long period of time, to the extent to which the electoral justice is not dispensed with as quickly as possible. So that complementarity needs to be enhanced. And I think as we go into discussions and further interrogating this, there is need to really ensure that that complementarity between the two is enhanced, and the capacity of informal dispute resolutions is also enhanced and increased. For those that I think I kept referring to the CEDROPS project, I've put in the link below in that presentation, and it's one project that you can look at in terms of how it managed to codify some of the judgments that were coming out of the courts and some of the challenges and the assessments of election dispute resolutions, and possibly also how they can be strengthened. And it is a valuable resources that you can look at. For now, I would like to thank you for your attention, and I hope this discussion is also managed to bolster and contribute to discussions that we have had since morning, and hopefully for those discussions that we are going to be having going forward. Thank you, Mr. Moderator, Madam Moderator, for this presentation. I hand back to you.
All right, thank you very much, Tawana, for taking the time out to join us and to make your contribution. Now we have a few minutes left for a plenary. If anyone has a question, please may you raise your hand, and then I'll just take a few questions, and then the panelists can respond. Yes, ma'am.
I don't have a name, but I'll give points. My name is Ipora Gichana. I'm from Kenya. I sit in the Magistrate Court, but I'm also the Secretary in the Judiciary Committee on Elections. Thank you, our panelists, for the discussions that you have led and for the insights that you have given. I want to make a comment in relation to the paper that was presented by our second presenter, my brother from Nigeria. My question is, where is the role of citizens in building institutions? Indeed, we must, as citizens, be able to criticize our institution. It is our duty. But when we come to the area, especially of social media, and how that criticism at times is engaged in, we must ask ourselves, are we throwing out the baby with the bathwater, or are we really building our institutions? We have seen in some countries, perhaps I'm not quite, let me speak about Kenya. When we look at our electoral management bodies since 1997, we have had an electoral manager who had a very tough end to his career. And on and off, we sit back and wonder whether we were really fair to some of those managers with the kind of rabid criticism that we engage in social media and other forums. Yet we know that these institutions are self-regulating. There is a way in which we can lodge complaints. There is a way in which we must encourage our citizens to still follow the rule of law, even where they feel that institutions or judges or persons have disappointed them. I just wanted to know what your comment on that issue is, and what is our role as citizens, and especially in the age of information, where really, as much as we are not adept, all of us in whatever professions, we still can get a lot of information, because this is the age of information. Thank you.
Thank you very much for that. Is there anyone else with a question or a comment? If not, Bukola, would you like to respond to that?
Thank you very much. I think I spoke from the angle of what the citizens are doing, why we keep asking questions and attacking the people. That is to the extreme, because social media, as I think from what Prof said in the morning, happens to be one of the instruments, that we enhance democracy in the 21st century. We cannot do without it. It has come to stay. At the same time, it's one of the instruments that can actually destroy the democracy we have chosen to adopt. Why? Because I don't know if you have observed this. In this age, this is the age that everybody is a journalist. Everybody can report a news. If anything happened here now, before people will even rescue somebody that fall down here, you are likely going to see people removing camera and, first of all, snap to tweet and say breaking news or it's happening now. He is not a former journalist, but social media has opened a space for people to talk. And that is where is the nexus? Where is the connection? Because in some instances, for instance, in Nigeria, there have been about 3 attempts to regulate the social media. But the aspect of where do you draw the line on human rights,
freedom of speech. Why some people, why we agree that it has to be regulated, but to what extent? Because there is a thin line between that. And in fact, this is all about technology. Our former president banned, for instance, Twitter sometimes ago. I don't know if you are aware, banned Twitter. But what the citizen did was to use what is called VPN. VPN will make you begin to operate as if you are not in that country. So they banned Twitter in Nigeria. So people downloaded VPN, and the VPN you have the liberty of choosing the country. You see people choosing Germany. I remember I chose Zimbabwe. And I was tweeting from Zimbabwe, and I was not in Zimbabwe. Some people were tweeting from Canada. So they were still talking. So there is a limit. However, there has to be a concerted effort. Again, what to answer directly, social media has also helped to build institutions. For instance, because of the barrage of social media, the cyber attack we had on the judiciary at some point in time during this last election, and I give you an example what happened. After the Presidential Election Petition Tribunal delivered their judgment, so they released, the party that want to appeal requested for the CTC certified true copy of the judgment so that they can use it to appeal. So we don't know what happened, but one of the judgments circulating on the social media was written Tinubu presidential team, legal team. So people started saying, oh, the man had the judgment before it was given. So they started, and meanwhile, somebody was so mischievous who put that there and posted it. Now, people started attacking. Now, this is where I'm going. The traditional court of appeal, who just want to be seen and not to be heard, or heard and not to be seen, will not do anything. But because people were already talking, the court of appeal tweeted for the first time to debunk and say, no, that did not emanated from them. And for the first time, they released free of charge online the copy of the judgment. Unprecedented. They don't do that. But maybe social media has helped accountability within that court process to be able to be proactive. We are likely going to be seeing more of this, of people talking because they feel it is their constitutional right to talk. However, the point is institutions have to be proactive to bring out information, not to be reacting and debunking. Let the information come from us first, and then people flow with it. So I think that is basic thing. The other one is citizens, most people don't fact check. In fact, one of the things research told us that TikTok and WhatsApp, they carry the highest number of percentage of the platform where fake news, misinformation spread faster. For instance, my Lord, I have to have your number for me to receive a WhatsApp message from you. So for me to have your number, there is an element of trust. So when you forward something to me, I might likely believe it than reading it anywhere. So, and people keep forwarding without fact checking. Now, we want to fact check. We approach the court. Please, this is what is going on. Can you give us, as simple as give us the number of cases filed? In fact, I experienced this. Give us the number of cases filed. In fact, the process to get the number of cases filed is as good as if I am petitioning. Because you submit the process, you submit it first, somebody stamp, somebody look at a whole lot of process, as if it's just information I need. How many? And do you know what? By the time you now go online, maybe it is 1,209 petition that was filed. I'm telling you the mindset of the citizen. If you are not releasing that, the citizen go and said 5,000 petitions were filed. You now rush out to say, no, it is 1,200. Why not give us the 1,200 initially? So people use that strategy to get information. And I think in the age of social media, in the 21st century, we might begin to adapt our judicial institution to conform with the trend, not in a negative way, but we need to now begin to see the nexus between the technology. In fact, it's the social media we are talking about. AI is coming. AI, how is it going to affect the judiciary? And I think those are the things. So citizen will talk, it will build the institution, it will help accountability, transparency, because people can see what is going on, people can actually talk, but we have to balance it so that we don't push out misinformation. Thank you.
All right, thank you, Bukola. We're out of time, but okay, sir. You can go
Thank
ahead.
you, Lady Moderator.
Yes.
David Mangota is my name, Judge of the High Court, Zimbabwe. I would say that what came from our brother from Nigeria is what I may refer to as the brutal truth of the thinking of the electorate in any given situation. I'm also aware that civil society interacts with the judiciary at some stage, and the electorate in the country they operate from. My question to you, my brother, is what can civil society do to make the electorate in their own countries understand the thinking of a judge in any given judgment? Because I think basically the challenge we have is the ordinary person who is not schooled in law does not understand the thinking of a judge. And that's why we get these attacks. What can you do?
What we have been doing is sensitization. For instance, is to take voter education beyond election day. And like I said in my presentation, petition litigation, election petition litigation look like it has come to stay. So we should rethink our voter education curriculum and begin to put electoral justice curriculum, basic thing, into our voter education curriculum. For us, that is one of the things we did. In fact, one of the things we did was to set up a dashboard online. So petitions and the proceeding, we put it online. So the courtroom are small, everybody cannot be there. So the Court of Appeal accredited us, gave us a letter that said, we recognize you as civil society to be in court. What do? We now put some of those processes, put it on a dashboard that you can go and read. So you know when they are at pre-hearing, what is going on. You know when the judge has given ruling. Now, civil society, this is our role. However, for us to get to that point, it took a lot of time for the judiciary to open up to civil society, because that perspective that, oh, they are always criticizing, we may have to rethink it and identify those. Of course, some people are criticizing unnecessarily, but there are people who doesn't want to antagonize, but they want to collaborate with you and pass the message. So that is exactly what civil society can do now. Educate the people beyond how to thumbprint, how to cast your vote, and with the basic thing of electoral justice. I think that is one of the things civil society need to do and that we are doing. Thank you.
Thank you. I'm Justice Kachale from Malawi. I wanted to ask Dr. Tinenenji on the comments she made towards the end about election petitions are not always democracy enhancing and weaponization of the judiciary, suggesting that election petitions can undermine democracy at times. what democracy are we talking about here when we suggesting that a constitutionally arranged and agreed methodology for resolving conflicts may actually be part of the problem? Isn't the value and the beauty of democracy that you have mechanisms for resolving your conflicts, and the constitutional order can actually empower certain people to handle those conflicts? Now, if you delegitimize that process, what kind of democracy then are we conceiving? Is it a matter of the judiciary trying to improve its processes, or is it a question of saying that the judicial process is not suited to resolving political conflicts? I'm a bit lost there.
Thank you for the question. I think the formal court system is very well suited to resolving political contestations. And I think that's why, like I mentioned, after the wave of political liberalization in many African countries, you know, the democracy was consolidated and courts began to hear election petitions. And there was excitement because this was something that had not been seen before, where an aggrieved party could go to court, question the incumbent, and hopefully win, even though that was very rarely the case. So my critique is not about the suitability of the formal court system. In fact, what I hoped to convey was that the formal court system is actually the best arbiter of political disputes because they can shape the trajectory of the law in a way that they're now prevented from doing because of this mass influx of cases into the system. And I think that this mass influx is indicative of failures that have nothing to do with the judiciary, that have to do with the greater electoral justice ecosystem. And I think that because the buck tends to stop at the judiciary, like you said, you know, you can't get it at the ballot, get it in court. So the buck tends to stop at the judiciary, and therefore all the negative focus is on the judiciary. But the only reason the judiciary is getting those cases in the first place is because of all the failures prior. So I think mine is really a defense of this space that this important space the judiciary has to articulate, to develop functional jurisprudence on things like materiality standards, for instance. The reason why judgments are conflicting is because courts do not have time to develop functioning jurisprudence on electoral petitions. So mine is more, I suppose, a call to protect courts as they should be handling exemplar cases and not be sort of resolving these run-of-the-mill cases, which a lot of times are designed to meet strategic political goals. I'm not at all questioning the right of a citizen to bring an electoral case. I'm just saying it's really, it's dysfunctional. There's something dysfunctional about an electoral system where 50 to 60% of cases are challenged. An electoral petition must be an anomaly, and it shouldn't be the norm. What about the access to justice implications of Zambia is similar to Nigeria in the sense that for the 90 days that courts are deliberating on electoral petitions, everything else comes to a standstill. And, you know, the political contestations then take center stage. So what happens to those cases, and what are the access to justice implications? So I hope that makes my position clearer.
Thank you so much, Tinenenji, for clarifying that. And thank you everyone for engaging with this panel. Over to you, Mr. Tsonga.
Thanks, Skanyisile. I think let us give Skanyisile a round of applause. She came at the very last minute, and she's been able to do a good job, and with all the party resource persons. This brings to an end the day. Wow, I think it has been brilliant. The resource persons, they've all given us new angles about everything. So, after lunch, you tend to say it's the graveyard session, but I could see all the judges, all the participants really, really looking live. So I really want to thank the organizers for an excellent choice of partners, and I hope tomorrow we'll continue on this path. Today, the JSC has really given us an excellent evening. They're spoiling us dinner at the Boma. I've no doubt that is going to be fantastic for all of us. The only downturn is that we need to be at the foyer by 6:20. Wow. You're enjoying too much. So we didn't want to stop the proceedings. So let's really try as much as we can. I'm going to ask that we stand to allow our Chief Justices to leave, and then we follow. And then let's really, really try to be out there by at least 6:20, so we can have a wonderful evening. And don't bath, you can just freshen, ladies. Thank you. Good night.
Dali soifule basi pala uche sabro zako. Vula, para sabro zako.
Señor,
Ya?
¿verdad?
Sí.
Mira,